ಓಪನ್ ಆಯ್ತಿಲ್ಲ, ವಿಡಿಯೋ ಬಂದಿಲ್ಲ, ಆನ್ ಮಾಡೋಣ ಅಲ್ಲ.
ಅದು ಅವ್ರು ಬಂದ್ಮೇಲೆ ಅದು ಇನ್ನೊಂದ್ಸರಿ ಆಫ್ ಮಾಡಿ ಆನ್ ಮಾಡಿ ಸರ್, ಅವಾಗ ಬರುತ್ತೆ.
ಸರಿ ರೆಡಿ.
Yes.
My lord, reporting settlement. Reporting settlement, my lord.
Tomorrow.
My lord, auction sale is slated on 30th of the month.
Huh?
Auction sale is slated on 30th of the month. If I
When
can
did you
request.
file the rectification?
I have filed it on Friday, my lords. If I can
If
request,
office objections are compliant, let it come.
I'll come.
With respect to a disposed matter, my lord, the filed an application and the 14 of the legislation actually exclude the time spent before this court. My lord.
Yes, tomorrow.
My lord's coordinate bench of this honorable court has ordered to pay 80 lakh rupees through installment, my lords, within 12 weeks. But petitioner had failed to comply with the orders of this honorable court. Now they are willing to pay all amount, my lords. Today they are ready to pay 35 lakh rupees by way of DD, my lords. Kindly take this matter.
What is outstanding?
Huh?
What is outstanding? What is the outstanding amount?
35 lakh, 80 lakh rupees.
Then why you will pay 35
Within
lakhs?
4 months we will pay, my
That
lords.
all that I will not hear this side of the vacation.
My
Yes,
lords, kindly, my lords, this matter
That's
is
loan
grave of
account
urgency, my
regularization.
lord.
Loan account regularization.
take that tomorrow. Yes.
Ellen
The
order, sir,
the
tomorrow.
bank, my lord, this honorable court has passed the order not to issue sale certificate for 4 weeks, my lord. In violation of this order, bank has forfeited my amount, my lord, 30 lakh rupees, my lord, which I deposited.
What is the interim order?
My lord, not to confirm the sale for 4 weeks, my lord. In spite,
What is it?
my lord, it was on 17/3, my lord.
Hmm.
17/3, this court has passed the order, my lord. Violating this order, the bank has forfeited my amount, my lord.
Oh, what is the connection between the two? Interim order is not to confirm the sale. If they
Please,
have a right to forfeit your account, they'll forfeit.
Please, my lord, without following this order passed by this honorable court, the bank has forfeited, my lord, within 4 weeks, my lord.
Non-confirmation of the sale, forfeiting your deposit are two different things.
My lord, not to confirm because there was a pending. I am the borrower purchaser.
But they have
my lord.
not done.
My lord, now they have forfeited amount and they are conducting fresh sale, my lord. Within 4 weeks, they have issued notice, my lord, for me without following the order passed by this honorable court, my lord.
Which bank is that?
DRT, my lord.
Which
Hello?
bank is that?
This is Bank of India, my lord.
Yes, tomorrow.
Tomorrow, please.
My lord, appeal was dismissed due to non-compliance of office
When
objection.
was it?
12/11/2025, my lord.
You move it on 12/11/2026. Not now. Yes,
My lord,
Commonwealth.
Page wise adjournment,
My lord.
page number 1, page number 4, page number 3, cell number 11 to 13, page number 5, cell number 14 to 17, page number 6, 18, page number 7, 19 to 21,
Serial number 21, my lord. Serial number 21, we are for petitioner. Connected matter is there. 1 week adjournment, senior is inconvenience.
Have you informed the other side?
Yes, please, ma'am. Please, ma'am.
This is matter after vacation. It is submitted that the same is informed to the council for the respondent. Is next.
cell number, page number 8, cell number 22 to 29,
22, my lords, appearing for petitioner, you have to file some translated copy in that. It brings time.
Have you not informed the other side? Then please wait till your matter is called. Yes, next.
page number 9, cell number 30 to 34, page number 10,
Serial
35.
number 31, my lord. I have informed the other side, there is some personal inconvenience.
Anyhow, these MFA matters will not be taken up. I'll admit it and post for final hearing.
Much of.
Page number 10,
So
cell
this
number
31, 32, admit final hearing, and 33 also. Where in all the matter TCR is there,
Yes,
just
sir.
admit final
Yes,
hearing.
yes, sir.
Next.
page number 10, cell number 35 to 41,
37, my lord. I am the respondent to my lord. I have updated the prisoner counsel because counsel is, I am the proxy counsel. He is slightly preoccupied in some other work. Kindly.
Conform to the petitioner's counsel.
Yes, my lord, I updated.
After vacation, at the request of non-counsel, the respondent is submitted that the same is informed to the petition. Look at it. Interim order is there extant. Yes.
page number 11, 42 to 48,
Serial number 46, my lord.
42.
Petition become infractious, my lord. On
Memo.
behalf of petition, memo I will file.
It will counsel for the petition submits that the petition has become infractious. And a memo is filed in this regard. Accordingly dismissed as infractious. Memo is
My
taken.
lord, 42, man.
Huh?
42, my lord.
Yes.
After vacation, my lord, I am petitioner, my lord, the only government is the party. Immediate cap.
Yes, Ajay.
They seek for farming of road. We have not farmed the road in there. They say that it's a private land. It can be disposed of. It can be disposed of with the, it can be
That's the
disposed of.
case, yes.
Yes, madam.
Page number 12, cell number 49 to 55.
Seal number 53, my lords.
Yeah.
For the petitioner, my lords, the arguing counsel, my lords, has suffered an accident. He's torn his ligament. The same is informed to the other side as well, my lords.
At the
Have it
request
after
of land
vacation.
counsel, the petitioner lives this matter after vacation. Same, submitted that it is informed to the other side.
Page number 13,
In all these adjourned matters, if there is interim order, look at it before all. Yes,
page number 13, 56 to 63. Page 14.
all final hearing MFA matters after vacation. The 34 after vacation, 63 after vacation on 4th of June.
Page
Yes.
number 14, cell number 6, part-time matters. 67.
Don't have to mention, call that.
List number 2,
The serial 65, my lord, Saturday is supposed to be got listed. I
Huh?
mentioned the matter, serial 65. And my lord, this honorable court posted the matter Tuesday, tomorrow, and it got listed today. My lord, have it tomorrow, my lord, day after tomorrow, my lord, I in fact, one other
Day
response.
after tomorrow not possible. On Wednesday, we'll have it tomorrow. Yes, this is matter tomorrow, 65.
Great.
At the request of land counsel appearing for the bank.
Respondent.
Interim or anything? Extend. Yes.
list number 1, for orders matter, cell number 1, G. Sukumaran, for petitioner, Shailesh SK.
Appearing for the respondent. My lord, they have filed application for recalling, but there's a.
And they're not present before the court.
Yes, ma'am. Matter can be dismissed.
This officer takes proceeding.
This is dismissed when?
Yes, ma'am.
On 4th June 2024. When is this filed? When is the recalling application filed?
My lord, 13/3/2026.
30?
13/3.
13/3/2026.
Yes, ma'am.
Where is that affidavit? You can disconnect it again, reconnect again. Is he muted? No, he can disconnect and connect again. Why is he staying there on the line like that?
There is delay, he has to file an application for delay, that is the officer decision based on the application.
Petition, the office objection shall be complied with by 4th of June, or else the IA shall stand dismissed without further reference to the court. S2,
Cell number 2,
Appearing for respondent number 4, my lord. My lord, we have not received the copy of writ petition yet. my lord.
2022 writ petition. No representation on behalf of the petitioner. Land counsel for the respondent submits that so far the copy of the writ petition is not served on the council. List this matter for dismissal tomorrow.
My lord, a similar matter has been posted for 5th of June.
Let it come, doesn't matter. Yes, please.
cell number 3, Dilip D, for petitioner. Dilip D,
Yes, list this matter for dismissal, no representation. Yes, for tomorrow.
cell number 4. Cell number 4,
I am for the petitioner. Third respondent is DRT.
What third respondent is?
Third respondent is DRT, for whom notice is not required.
Required, yes. Then why was it made a party?
Formal party we have to make, we make. No notice will be
Tribunals
ordered.
are not necessary to be made as parties. Not necessary that they should be made parties. Anyhow, yes. What is the order?
Very simple. I file an SA before the DRT My property is mortgaged by somebody to the bank. They attach my property. They drive out my tenant, lock the premises. Now it is like a hell. It has become a dump.
The DRT say, let's look at the order.
Interim order was granted, staying the sale process. Kindly see in page 29, my prayer in the DRT. It is well settled law that all questions.
Let's understand and see what is the order passed for the DRT, page number.
Impugned order is that. Annexure B, my lord. Annexure B, my lord. In page 127.
Let us look at your petition filed before the DRT.
Page 29, my prayer. Page 29, my prayer. Internal page 16, page 29. To declare that the alleged mortgage by deposit of title deeds.
How can the DRT pass its order? Apart from the sale, is questioning the other issues. It won't become infructuous.
My lord, the facts of the case are like this. This bank is Advocates Bank, Nyayamitra Cooperative Bank. He borrowed the loan and obtained the
Whatever it is, let us not go into the facts.
Please.
Now the court has dismissed the essay as infructuous because sale had not taken place. Apart from that relief, he has sought several other reliefs. Whatever right, wrong, whatever it is, there should be an order on merits.
May I request your lordship to have wait. Day after tomorrow, I'll come and
Nothing to clarify. Why to have it
What
only
is
after
there?
tomorrow?
one submission. See, your lordship may kindly see, already before what they have alleged that they have purchased the property, it was secured by the bank.
Who has to say that? The court has to, the RT has to tell all this by passing an order. Just because the sale is conducted, we have said, the essay will not become infructuous.
Sir,
Look at the praise he has sought. That has to be adjudicated by the DRT. Already this is pending here from 23. Why should we adjourn it? Please come.
May I request your
Ultimately, if they say they will pay for the damages,
What is
I
it?
will wait.
1 minute.
may I request your lordship, remand the matter back.
That
to
is
the
what,
DRT.
that's what the court will
With
do.
a stipulated time, they let they dispose of it.
Yes.
Because our money is seized.
Yes.
Now we cannot proceed with it.
Yes, yes.
It is advocates of money.
The present
which has been-
petition is filed seeking the following prayer. The petitioner, it's a case of the petitioner that he is a third party. He is neither a borrower nor a guarantor. The respondent bank has initiated the proceedings with respect to the property belonging to the petitioner and issued the auction notification. Questioning that, he had filed essay number 46 of 2023 before the Debt Recovery Tribunal. Initially, on 21/2023, an order was passed that the sale of immobile properties fixed for 23/1/2023 at 3:30 p.m. pursuant to the public auction sale notice dated 23/12/2022 shall go on. However, the confirmation of such sale is stated in the next date of hearing. Another order came to be passed on 15/2/2023, wherein the DRT has observed that since the sale did not materialize on the scheduled dates as stated by the counsel for the bank, the prayer sought in the essay to set aside the auction sale is rendered infructuous, and accordingly essay is disposed of as infructuous. Agreed thereby, the petitioner is before this court, who is the applicant before the DRT. When counsel appearing for the petitioner submits that In fact, before the DRT, the petitioner has sought for several prayers. One of the prayer is one of the prayer is questioning the auction sale notice. It is submitted that the DRT has to consider all the aspects with regard to the mortgage and with regard to all the steps that are all the measures that are initiated by the bank. But without going into the merits of the matter, the DRT has dismissed the appeal as infructuous, which cannot, and the same is liable to be set aside. Land counsel appearing for, you are for?
Respondent number 2, bank.
Land counsel appearing for the bank submits that as the auction was not, auction could not be materialized. The tribunal has rightly has dismissed the essay as infructuous and nothing remains to be considered in the said essay. Next paragraph. Having heard the counsels on either side, further material non record. The petitioner has approached the DRT questioning the surface proceedings that are initiated by the bank in respect of his property, which is not mortgaged to the bank. And he has raised several other grounds along with the ground that the sale notice is back. If the sale is not concluded, the essay will not become infructuous. And the DRT has to consider all the grounds that are raised by the petitioner and the reliefs that are sought by the petitioner before the DRT. The considered opinion of the court, the dismissal of the essay as infructuous by the DRT is bad and the same is liable to be set aside. Accordingly, this court is passing the following order. The order dated 15/2/2023 passed by the DRT in essay number 46 of 2023 is set aside and the matter is remanded back to the DRT for fresh consideration. Number 2, considering the fact that this is an essay of 2023, the DRT shall consider the same. DRT is requested to consider the same as expeditiously as possible, but not later than 8 months.
All contentions are left.
All contentions are left open to the parties.
Number
Yes.
5.
Date for appearance may kindly.
Yes, without further notice, the party shall appear before the DRT on, because it works in May, we'll give a date in May. Lists shall appear before the DRT on 14th of May.
Please.
And order copy in 2 days. Yes, next.
Till number 5, Proceedings for petitioner KV Lokesh.
Lordship filing memo of withdrawal
Take that.
Hearing for respondent.
with the liberty to approach the DRT, my lords.
What is questioned before the court?
The sale confirmation letter,
Sale notice has been challenged.
sale notice as well as the confirmation.
What happened to the sale? Sale has taken place?
Yeah, already sale has taken place, Lordship.
The writ petition is filed seeking the following prayer. A memo is filed seeking to withdraw the writ petition. With the liberty to approach the DRT. Land counsel appearing for the respondent submits that already the sale had taken place.
Yes, Lordship.
So taken place in that view of the matter. This court is passed the following order. The writ petition is disposed of. Section 14.
My lords,
Within 30 days, you shall approach the DRT.
please, my lords.
Yes.
H.H. Umesh for petitioner.
No representation for dismissal tomorrow.
Cell number 7.
For the petitioner, ma'am, filing memo for withdrawal.
Take that. What is the relief that is sought in the writ petition?
Milord, Section 14 order is held before this honorable court. Milord, in fact, this honorable court granted an interim order They're not complied. Earlier also, my lord, they approached this honorable court as well as DRT.
Then why should we give you, I'll not say that about section 14, will not give you that benefit.
My lord,
You have an interim order in your favor on 25/11/2025.
Yes,
You
ma'am.
don't comply with the order, and why should we give you the liberty to approach the DRT? I'll dismiss the petition. I'll hear it and I'll dismiss it.
A liberty may be granted.
Huh? Why should we grant?
My lord, I will take the instructions.
Why you take a interim order, enjoy the interim order, and don't comply with the order and now come before the court and say, I'll go to DRT? Isn't it an abuse of process?
Correct.
What had happened after this? You have not, when you have the say, you have not conducted.
No.
More than 4 crores outstanding.
Impugned order is stayed.
On 25/11.
No precipitative, further, no precipitative action shall be taken. We'll hear the matter, what is wrong with this order. Please argue.
Then
It's very
passed over.
unfair.
Maybe passed over
Yes.
My lord, it's a matter
for
by
the petitioner.
My lord,
Well, I'm filing
the order-
written arguments.
I also filed, my lord, already placed before it.
What about that? Let me
Please, my lord.
do the file.
My lord, the relief sought, my lord, page number 16.
My lord, one request, my lord, it may be passed over. My colleague is coming.
Every time, my lord, kindly see, my lord, there are 6 or 7 adjournment. Every time, my lord, matter
Passed
got
over,
passed,
if he
passed
does-
over, then
Please understand.
I filed my
Another
written
matter is
arguments.
passed
I'm
over.
not taking
If it doesn't
action.
turn up, I'll hear your arguments and pass orders.
in this matter, at least 4 or 5 occasions, my lord, passed over.
Mr. Vignesh Shetty, I'm saying I'll
so
pass
sorry.
orders in the
I'm so
afternoon.
sorry. I'm so sorry.
Yes.
Grateful.
Cell number 9.
Yes, counsel for the respondents number 1, 3 and 4 filed wakalat request for copies.
My lord, in this case, my lord, this is a petition under section 14. It's honorable that even that CMM court has ordered that these people cannot do that borrowers cannot appear before under section 14. So they have dispensed with the services. Here also I'm making application to dispense with the notice because they have nothing to say. I will file it today only, my
Before this court.
lord.
Why are you before this court?
Under section 14, it was dismissed. That section 14 was dismissed on the ground, stating that bank has taken physical possession. In fact, the authorized officer went to the branch and want to take physical possession. Borrower refused it. Then he pasted that possession notice on the premises and left it, and then filed the application before 14. Then that CMM court says, no, you have recorded the Panchanama, you would have taken the possession. Then that bank filed an affidavit stating that you have not taken possession, hence kindly consider our application. Then on that, in spite of that, the application was dismissed. And in fact, that section 40, they have got very limited jurisdiction on filing the affidavit, whether they have to see whether that possession has to be given or not. But this honorable the court said, no, because you have taken Panchanama. When the bank has filed the affidavit stating you have not taken Panchanama because that borrower did not oblige, they refused to give the possession, then he pasted and come.
No,
That is why they filed the application on 14.
What is the other material before the court? No, none else represents before the court except you.
Yes, only that.
So,
That is why this honorable court permit us to approach that under section 14 again, my lord, because they have dismissed for this reason.
let's see.
That order you may kindly see, my lord.
Still on.
Because your presence.
Nala, there's one more request, my lord. One, R2 is no more.
No, my lord, that there.
Await service anta ide. Notice has been ordered to
In
all
fact, my lord,
parties.
in the last.
Last data wearing notice is ordered. That's why we are before the court. Copies are not given.
No, my lord, that I am filing the application to dispense with. that
How can he?
copy that,
us from?
my lord, that order
We have to
itself,
pay money. We'll settle the matter if
My lord.
necessary. I would settle the issue.
No.
my lord, that page number you are kindly see, my lord, that order passed by that.
He serves copy. I
Page
will
number 50,
advise
page
clients
number
to settle.
51.
Anyhow, the court has issued notice. They are before the court. Whatever is a limited submission with regard to this, court will take.
Yes, ma'am.
No difficulty
Yes,
to
my
you.
lord.
Serve papers on them.
Please.
Counsel the petitions or the papers on the counsel appearing for the.
And one short date may be given, my
This
lord.
matter on,
R2 is dead. Let him take steps.
on 3rd of June.
Third, and that day I will file application also, my lord.
Yes.
He is refusing to serve. He wants to file application.
Cell number
Well, that I will
Order by the
serve.
court.
That I will serve, my lord. Meanwhile, I will file the application on third.
We'll consider
Yes,
both
madam.
because I've
Both.
already issued notice.
Yes, my lord.
Now there is no point of you saying
Yes, yes, that is true, my lord.
dispense with notice.
No, on the same day that we'll consider, my lord.
Yes, yes.
I filed memo, but the sale notice is challenged in this petition.
Yes, a memo is filed seeking to withdraw the writ petition. As the writ petition is filed against Axis Finance Limited, and this court has expressed the view that the writ petition against the same is not maintainable in the light of the law laid down in Vishwa Bharati's case. Yeah, in view of the same, the memo is taken on record, and the writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy before the DRT. Same section 14. You shall approach the DRT within 30 days from the date of receipt of the copy of the order. In all these matters, whenever say 30 days, on the same day the order it should be typed and given. Yes.
Please. Second respondent, madam.
On the last occasion, may it please the court, on the last occasion, your lordships were pleased to allow our impleading application. I think the petitioner will have to carry out those amendments. And
Yes, I will carry out the amendments, my lord. I'm sorry. And my lord, today the matter was for the union to file their objections. They have not filed any objections as on today.
The petitioner shall carry out the necessary amendments to the cause title. This is this matter after vacation. Yeah, if interim order is there.
I have one submission to make, your lordship. I am for the second respondent. This is arising out of a original suit filed by the petitioner here. There are two applications which came to be filed by me. One, both under Order 7, Rule 11. One challenging the objection of plaintiff under Order 7, Rule 11 for the purpose that the suit is not maintainable in view of the bar under Section 5(2) of the Hindu Succession Act. That is challenged before the Honorable Court. To that effect, the application is not to be disposed of, is the interim order passed here. At the same time, I had also moved one more application, again under Order 7, Rule 11 for non-payment of proper court fee. Unfortunately, even that application is not to be heard, is the order passed. Let that be clarified so that I can pursue that.
That is an independent application.
That's an independent application.
Why it can't be heard?
And that has nothing to do with this law, Alicia.
Where is that? Where is that order?
That order, the day one it is made, my lord. On 2nd of December 2015.
2nd of December
2015.
Added from stay of further hearing. Insofar as the application filed under Order 6.
Order 7, Rule 11.
Why it should be stayed, Mr. Counsel?
well, may I just clarify, my lord, subject to your
Yes.
lordship's permission? Well, this
Yes.
is a case, my lords, where the issue pertains to succession, my lords, under the in terms of the whether or not the original customs would prevail or whether the Hindu Succession Act would prevail, because this pertains to the Mysore royal family. Now, the partition suit has been filed by the writ petitioner herein. I have also been transposed as a plaintiff. In the meantime, my lord, the writ petitioner had filed this writ petition assailing the constitutional validity of Section 5(2). Now, my lord, a number of judgments of the Supreme Court have come out since then, which we'll bring to your lordship's attention on the next date, wherein the Supreme Court has clarified that it would have to be the ordinary rules of succession that are applied and the exception under 5(2) would not apply. That's the clarification that we'll ultimately seek from your lordships. Now, whether or not the union files its counter, if your lordships have it on the 4th of June, it was supposed to have been listed on Friday, my lords. I was physically present in Karnataka. I'll come down, my lords. Your lordship may have it on the 4th of June, subject to your lordship's convenience. And if the interim order requires any clarification, your lordships may consider that also on that date.
What he says there are two applications. The other application is with
Yes.
regard to the deficit court fees, or that the plaintiff has to be rejected for that.
Well, that
Well,
also
they've both been filed together, your lordship. Ultimately, it can be
There is
considered
absolutely
holistically
nothing as far as
together.
pleading is concerned in this writ petition as far as that is
So,
concerned.
for example,
That is true.
if the court gives a finding in favor of the petitioner,
Yes, my lord.
what would happen to the application that is already decided?
Lords may kindly see the
As far as
interim
that is
order.
concerned is only for the purpose of court fee. Without paying court fee, they cannot pursue
My
the
lord.
case. That is an independent application
The-
which is filed, and that is not called in question here.
No,
The
no.
entire writ petition
What
proceedings.
is called in question here?
My lord,
Only with respect to the second application under Order 7, Rule 11D, which is calling in question the rejection of plaint under Section 5(2) of Hindu Succession Act. The other one is under the court fee which requires to be paid. That is an independent thing and that has nothing to do with this. Unfortunately, even that is stayed here. I'm only seeking this court permission so that that application be heard by me. The trial court can proceed with that because now day after tomorrow the matter is pending, posted for purpose of recording of evidence. Once the evidence is recorded, then where am I? Even that is also to be looked into.
My only request is, my lord, your lordship may have it on the 4th, my lord. I'll also
Let
go through the
further
interim
proceedings
orders.
be stayed. At least to that effect, let there be stayed. Till next date of hearing, let the entire proceedings be stayed before the trial court. Now, if that is the direction they get, they don't want to proceed with this. At least let my application be considered by the trial court. I'm only requesting the court so that that clarification is there.
So how can the trial go on in this in this piecemeal basis? His application, which requires to be considered at the threshold,
Yes.
it is not being considered, and the court is proceeding with the other proceedings. Isn't it an injustice to him?
In fact, there is an issue which is framed even to that effect as far as 5-2 is concerned. Now the trial will have to go on even on that.
No, let the court decide this as a preliminary issue.
Well, as far as that is concerned, no, I'm okay with that, but they don't want to.
As regards court fee, my lord, that can be considered as an issue, my lord. It is a mixed question of law and fact. That cannot be a ground in the 7
I have moved my application. I will address my arguments if that is the case.
As regards the
let the trial
maintainability,
court
I
decide
agree that
way.
it is here
No,
before this
as far as
honorable
the
court.
stay is concerned, will vacate. As far this stay dated 2/12/2015, with regard to that application has to be vacated.
As regards the
should we-
maintainability, my lord, of section 5.2, that is pending consideration before this honorable court.
Then why the other suit is going on?
The other suit is for partition. That is the main suit. In the main suit, a contention has been taken to say that the suit is not maintainable as under section 5.2, there's a bar.
If that is the
That-
case,
that issue has
that
been-
suit is already going on. If that is going on, why one of the issues should be stayed? We will decide this whether the validity of that application of Succession Act, but this can't be, there can't be an injunction restraining one application to be stayed and remaining proceedings to go ahead.
May I request for a pass over, my lord, senior counsel also will come and
Yes,
answer this
let him
question.
come.
Yes,
We will vacate the stay.
yes.
Yes.
Then number 12. Group Sitaram Rao, a petitioner.
This is a case where KADB, which is established to promote the industry in
Please
Karnataka,
come to the prayer. What is the prayer you are seeking in
to
the?
quash the alleged impugned order at annexure M, resumption of my industrial.
Writ of Sareshwari, causing the order dated.
They are not able to implement the project once the land is.
No, that is
allotted.
not the issue.
Number one.
First,
Number
let
two
him
is
answer.
he
This
has-
honorable court directed him
the
to
prices
furnish
are
certain
subject to-
particulars to this court.
They are
By
not
order
constant.
dated,
When is the order dated?
that this is dated 16/1/2020, 19/12/2024. 19/12/2000.
Have you done anything pursuant to this order?
No,
No, because of the proceedings, we will not be able to, 34 proceedings, we have cancelled the allotment. That is impugned. They
In that view of the matter, 3 weeks' time is granted to the KIADB to place all relevant documents in relation to the above. Have you placed it?
no.
Why?
We have filed our objection statement, my lords.
This order is dated 19/12.
I'll place it, my lords. I'm sorry, my lords.
Not-
I'll
You have
place
done
it.
it. It's been 2 years.
I'm sorry, my lord. 19.
Lord, another mischief that is.
19/12/2024 is the order.
Another mischief being played on this on court as well as the
Look, we have not
industrialist
made any mischief,
is
my lord. Such kind of.
board has, no, I am going to substantiate, let him keep his executive officer present to answer the court. Board has taken a decision not to charge in excess of 80 lakhs per acre because they could not implement the project in time for want of environmental clearance from New Delhi. After they've obtained it, board makes a
What we
resolution.
do is,
He doesn't,
immediately
it has,
after vacation we'll have, and by the time we shall place all the material before the court.
yes,
Pursuant to
including
order
board
dated-
resolution. My request
They
is,
don't want to.
there
use
is
the
a board resolution to say that we will not demand higher amount, we will allot the plots.
That discretion is always
As per
vested.
the order
In the
dated
board.
19/12/2024, the respondent shall place before the court all the relevant documents in relation to this dispute between the parties by 8th of June, or else who is the respondent? Who is that officer?
Lots,
CEO, my lord.
The CEO.
But may I
Which-
respectfully submit,
Which
my lords,
respondent is, yeah, the
may I res-
CEO.
one- Please, please.
The
may I-
CEO shall be present before the court.
But may I respectfully submit, please, my lord, one moment. But the secretary, my lords, he will be the officer who can answer.
Only executive officer is
Secretary, my
competent.
lords, he will be in a position to answer the questions. I'll keep, in the event it is not filed, I'll
No,
keep.
we don't want him just like that. If you don't file the affidavit.
Yes, we will file it.
Then
my
only,
lord. We will
if you
place it.
don't place the record, then he'll come.
The secretary, my lords, he will come. I place it, my lords, before my lords by that time. The file, I will place
So
it.
we'll say if the the objection, the material is not placed, then the second will appear. Even otherwise, the third respondent shall be present before the court to explain what has transpired from 2019. Yes, this song.
Interim order
Interim order granted is extended. This is matter on 10th of June.
But we have our, in the application form itself, it is mentioned. But the prices that are indicated are tentative.
Hear it on that
Please.
day.
Now, they don't want to, let's play the
That's
enhanced
what,
prices.
we'll hear it on, by the time if you have paid.
They don't want to complete the
No,
project.
by
Court
today-
says I have to pay
My
10
lords,
rupees, I will
By
pay.
today, had you
Not the
placed.
court, my lords. It is we who make the allotment.
No,
to
you
them.
are-
They are bound by our terms.
You are misrepresenting to the
If both
court.
of you are arguing what is the
Please,
use of it without the
I
material.
will place
on
the
record.
file.
Yes, next.
Number 13, P.O. Chandrasekhar, for petitioner, Jaiprakash Shetty.
I am for the petitioner, please. Seems some.
What is this IA 1 of 26?
Some person has filed impleading application.
You filed.
Please,
Who are you?
I am the first defendant in the suit filed by the petitioner. Duty and penalty order passed by the respondent 3 is the subject matter before this court. At the instance of the plaintiff, the matter has been referred to the Deputy Commissioner for duty and penalty. Order has been passed. That has not been objected by the other side. They filed a writ petition, and in view of the pendants of the writ petition, the trial court is not proceeding in the matter.
My lord, kindly recollect a similar matter. Your lordship has given directions to the petitioner to approach, and whatever the payment of deficit he has to allow, permit him to raise those questions before the trial court only, not before this court.
Is
Your
this,
lordship. This is
informing
second
of
matter.
document?
This is a second matter. I mean, similar matter your lordship has already disposed of. In terms
So
of
what
that,
is the order impugned? Let's see.
Well, let's, it's at.
Annexure,
Annexure A, page 17.
So,
Page 17.
by virtue of an
17
order passed by the civil court, by virtue of an order passed by the civil court,
Yes, please.
this order is passed by the registrar. Is it correct?
Yes.
If that is the
Calculation of
case,
duty and
can't you raise these objections before the civil court?
Before civil court, when it was being adjourned simply, then after some time, I argued the matter. Then civil court has said, but it is not observed in the order sheet. If I challenged in the writ petition,
You should have. You should have raised all those objections by way of a formal IA. And then the court has to answer to that. Without doing it, like as if it is like a writ of mandamus, you can't come here. It is arising out of a suit proceedings. That's for the civil court to decide.
well, it's independently I have to challenge the order
You
passed by
cannot.
this thing, calculation.
You cannot challenge. That
Calculation.
is what earlier in the writ petition have disposed of. You can't independently challenge. It is not that you have presented a document and something has happened. By virtue of the orders passed by the court, the registrar has taken a decision that you have to question it before the civil court by saying that whatever the decision that is taken is not correct.
That can. Lordship may kindly
Yes.
observe like this.
Please come. The present writ petition is filed, questioning seeking the following prayer.
Page 14 is the main frame.
Is a case of the petitioner that the petitioner has instituted a suit, that's OS number 7247 of 2018 for the city civil court before CCH 44. seeking the relief to declare the sale deed dated 27/8/2005, executed by the first defendant in favor of the second defendant as null and void and not binding on the petitioner. And also sought a prayer that the creation of security interest charged in respect of the Schedule B property by the second defendant in favor of the third defendant is a said suit as illegal, null and void. And also sought for a mandatory injunction. In the said suit, the petitioner has filed I number 18, seeking permission to mark the Xerox copies of the three documents, which included joint development agreement dated 9/2/2002, and I number 19, praying permission to produce the copies of the three documents, including the joint development agreement dated 9/2/2002. And the said IA was allowed, subject to payment of duty and penalty by order dated 16/10/2019. And it was calculated at an amount of rupees 36,31,430. Then the petitioner's counsel has filed a memo of calculation dated 6/1/2020 relating to duty and penalty. On 11/2/2021, the court was pleased to pursue the same and directed the office to send the joint development agreement dated 9/2/2002 to the DC concerned for calculating and recovering the duty and penalty on the said joint development agreement. On 19/4/2021, the trial court has received the duty and penalty calculation report from the third respondent. The advocate for the petitioner sought time to address the arguments regarding the calculation of stamp duty and penalty. It is stated that the petitioner has no other effective alternative remedy but to approach this court by filing the instant writ petition. This writ petition is filed. An interim order was granted. Where is the interim order?
Interim order irlikilla some.
It says interim order is granted.
Interim order irlikilla.
Just now you are submitting. Because of the writ petition and all, you said something. The no interim order is granted in this matter. In the suit, when a pending suit before the court, when any order is passed, even with regard to the stamp duty and penalty, the petitioner has a remedy to question the same before the trial court. And if he is agreed with any order passed by the trial court, he can come before this court. But he cannot assail the order which is passed by the registrar pursuant to the order passed by a civil court by filing a writ petition under 226 before this court. In that view of the matter, the writ petition is disposed of, giving liberty to the petitioner to avail the remedy before the civil court. Yes, next. And the IA, it should be the right the defendant has filed an IA before the court seeking to plead him as a respondent. As the petition itself is disposed of, this court is not passing any orders on the implied petition. Yes,
Petitioner.
Then number 14.
Petitioner may be permitted to file an IA before the trial court. Lordship said to avail remedy in accordance with law. I am permitted to file an application or objection.
That is what, sir. If it is the permitting of file an application, it will be. Yes.
Then number 14.
Appeal for petitioner, my lord. This matter was heard last occasion, my lord. It's regarding balance maintenance. I have taken DD for 4,60,000, my lord. It is payable in favor of respondent number 3.
What is this writ petition about?
My lord, this
Senior Citizens Act.
Senior Citizen Act, my lord, I have challenged the order passed by the appellate tribunal deputy commissioner, my lord. In all along in civil proceedings as well as the proceedings before the assistant commissioner and
Yes,
DC,
yes, I
they have
remember
taken the contents of that fraud and coercion. They have taken the.
Let's see, come to the cause title again.
Yes.
We'll understand.
Respondent number 3 is mother, my lord.
Mm,
She has executed gift deed on 4/7/2012
mm.
in favor of petitioner, my lord.
4/7?
2012, my lord.
Mm,
In favor of petitioner.
mm.
And respondent number 4 to 8 are other children.
4 to 8 are
Other children of
Siblings.
respondent number 3.
siblings.
Yes.
Mm,
Then after there was a partition suit filed by the
mm.
appellant as well as respondent number 6 and 7, my lord, against their mother, respondent number 3 and brothers. Thereafter, at the instance of her son, respondent number 4, they filed application during 2019 before the tribunal assistant commissioner, seeking cancellation of gift deed. The assistant commissioner, upon perusal of the facts and evidence, passed order granting 2,000 rupees each, payable by the petitioner as well as respondent number
It comes to how
5 to 8.
How
it
many
is
of you are there?
10,000.
1, 2, 3, 4, 5, 6 are there.
Yes,
It
no,
comes-
respondent number petitioner as well as respondent number 5 to 8.
Who is,
It is that claim that she is staying with respondent number 5.
who is 4?
For his son,
Uh.
her contention that she is staying with the respondent
5.
number 5. Sorry, 4, my lord. 4.
Saying one of the son.
Yes, one of this. That's why for others are liable to pay 2,000 each, totally amounting to 10,000.
Then what did the appellate authority do?
That is by the tribunal, assistant commissioner.
Hmm.
Then the respondent number 3, she challenged by way of appeal before the deputy commissioner, contending that the gift deed was procured under undue influence and playing fraud and
Set aside.
that's
That is set aside now.
that is the gift deed is set aside by the
What
appellant.
is what is his observation with regard to the maintenance?
In so far as observation, he has not made any maintenance observation that regarding maintenance, my lord. He straightaway said that it is responsibility of the children to look after aged parents. It is not being done by the children. That's why he straightaway proceeded to cancel the gift deed. My lord, the fundamental submission, my lord.
Now,
the-
when is this application filed before the assistant commissioner?
That is 2019, my lord.
2019.
Yes.
We are in 2026.
Yes. Gift deed was year 2012.
Hmm.
My lord, this is the issue covered by the.
So that, I'm not on that aspect.
Please.
That is that is second
Yes.
law. So from 2019 to 26,
Yes.
how many years? 7 years.
86 months, my lord.
You have calculated
Yes, ma'am. 86 months
into 10.
8,60,000. We have deposited 3 lakh.
8,60,000.
Yes, ma'am.
You have already paid till now
4 lakh. 4 lakh we have paid.
when
3 lakh deposited at the time of granting as per the condition imposed by the
that's
Honorable Court.
before this court now.
Before this court.
Uh.
1 lakh DD was sent.
When
That is immediately, my lord.
then
4,60,000 I'm paying, my lord.
now you have got 4,60,000.
Yes, DD for that.
Yes. He just said so. All those details, I'm aware of the details. What is whether the under the Senior Citizens Act, can there be a cancellation of the gift deed on these grounds?
But the tribunal order that even though the property was, 50 was cancelled and property was given to you, you are not in a position to cultivate since you are a first an order for maintenance. And I am not seeking for maintenance, only the section 43 of Senior Citizen Act.
This cannot be done under 23.
That is why I have preferred
The writ petition has to be allowed. That can't be done under 23. Please come.
moreover, because what the contention is that 11 acres, 7 hectares in survey number 26, 1 and 26, 2 of classified village is purchased by R3 or 4,42,000. 4,42,000. It is her self-acquired property now. ಅದು ಏನಾಗಿದೆ ಅಂದ್ರೆ before subsequently after the deed executed, the R3, R4 and R8 partition deed was executed. With the subsequently Gangama filed a suit for partition deed before the negligence court, including this R3 and R4 and other systems.
Please understand, all these facts will not have any bearing on this writ petition. Only issue which you have to demonstrate before the court, whether under the senior citizen, the tribunal can pass such an order of cancellation. In the light of the settled law, whatever are the facts, unless and until there is an aberrament in the gift deed saying that there is a clause for the maintenance of the donor. All these, that is not the part of the assistant commissioner will not have jurisdiction.
But they have people that power to cancel the
Provided that clause is satisfied.
Condition.
In this case, it is not satisfied.
that is the civil court notice they have taken, it is all the properties are not included in the partition group. That is why I have taken contention that property that is 11 acres was not included in the property taken.
Yes. Where?
Bottom line.
27.
23.
Oh. There is a condition.
It's not condition.
Taking care of the well-being of the owner. Next, ಮುಂದೆಯೂ thereafter ನನ್ನ ಯೋಗಕ್ಷೇಮ ಆರೈಕೆಯನ್ನು ಮಾಡುತ್ತೀಯಾ ಎಂಬ ಭಾವನೆ ಇರುವುದರಿಂದ there existed a condition.
Saying that.
Hoping that. That is only line, hoping that. Please.
ಮುಂದೆಯೂ ಸಹ ನನ್ನ ಯೋಗಕ್ಷೇಮ ಆರೈಕೆಯನ್ನು ಮಾಡುತ್ತೀಯಾ ಎಂಬ ಭಾವನೆ ಇರುವುದರಿಂದ saying that you will take care of me in future. If that condition is there, then
That is hoping that, my lord, she would take care.
That is the condition, that is what is contemplated under the act.
No, my lord, here the two things, my lord, the condition, my lord, she shall provide the basic amenities and physical needs, my lord.
It is not the interpretation.
That is another aspect, my lord. Lordship kindly see all over in the proceedings, my lord, she has taken contention that it was procured by playing fraud and under undue influence. It will not attract section 23, my lord. It is covered by judgment of this Honorable Court, my lord, division bench.
No. For all that judgments, whether it is fraud or other thing, in the gift deed, there is a clause with regard to the maintenance
There
of
is
the senior citizen.
no condition, my lord, subject to condition that the gift deed was executed, my
Settlement
lord.
is more than enough.
Lordship kindly see.
Only with the fond hope that fraud and coercion and other things, that is settled law. We don't have to look at.
My lord,
As far as the
section
clause is
23,
concerned.
my lord, that is correspondent thing, my lord, to attract section 23. Lordship kindly Where is section 23, my lord?
You read?
23, my lord.
Yes.
Twenty-three, my lord.
After the commencement of this act, as maybe a few
Do that, I will take.
property subject to the condition that the transfer is provided its condition and
23, my lord.
leads to the transfer.
That is fraud and this one, my lord. It is corresponding to breach of condition so far as gift deed is concerned, my lord. So far as general allegation of fraud and undue influence is different,
As
my
well
lord.
as, no, fraud and other allegations we cannot look into. Keep that apart, aside.
Yes.
Now, what about the other clauses of the gift deed? Now, the court, whatever the senior citizen has raised, but court has to look at when an application is filed under 23, whether there is such a clause or not.
Yes.
So such a clause is there.
Here, my lord, she has taken inconsistent argument, my lord. In the civil suit, she admits and has given deposition that the scheduled properties are joint family property. And she has supported her brother.
If it is a joint family property, now you have filed a suit for partition, we'll set aside this deed. No, if the gift deed is set aside and you are entitled for a share in that, you will get it.
No, my lord, here the my lord, lordship kindly see so far as the Sudesh judgment, my lord, please.
Please. Yes. Sudesh Shikara, yes.
Yes, para 4, my lord. It is not absolute condition, my lord. That's a lordship love and affection. It's clearly there in gift 2012, my lord. May I read the gift deed, my lord? 2012 gift deed, annexure A, my lord.
That's what he read now.
He read, my lord, it is not a condition, my lord. Nanna uttara kriya adi is and emba bhavane iruvudarinda.
According to you, how the condition would be narrated in a gift deed?
Subject to condition, my lord, that should
There
be
won't be
specific
a, gift
condition.
deed will not be a subjective this thing. It won't be on subject to some, it only says with the hope that you will take care of me in the future. I am executing the gift deed in your favor. That would be the amendment in a gift deed.
My humble submission, my lord. They have taken specific contention for cancellation only on the ground of fraud, and they have not taken this ground, my lord, before the assistant commissioner. That is my submission, my lord. In all our civil proceedings, as well as before the assistant commissioner, they only pleaded that they have created the gift deed playing fraud, and that is my contention, my lord. That's why
this is my clarification.
lordship kindly see.
The petitioner shall place
only
before the
this
court
Jayashankar case, my lord.
the translated copy of the gift deed.
Please.
Yes.
15. Rohan Kotari for petitioner. E. Anthony.
May I make payment of deed? Yes.
Take that. No, that is not because you accept the amount. That doesn't mean that the court will not decide. Take it. The petitioner has handed over. It's a DD or a check?
A DD.
DD for an amount of rupees?
4,60,000.
4,60,000 to the council appearing for respondent number 3.
Respondent number.
Yes.
E. Rohan Kotari for petitioner.
Ladyship.
E. Anthony Cruz.
This is that matter that Japanese National Police Company.
Yes. What happened after that? When an AG submits that, he would get instructions. If by the time objections are not filed, the concern shall appear before the court. Objections are filed?
No, Your Lady.
Only problem was that since it is a state of Japan, not the bank. Now they can place the undertaking, we release it in the
I have two options. That undertaking is already on record. That undertaking can be taken as a part of today's proceeding. There are in fact two alternatives. One is that the payment be made to the petitioner's counsel with an undertaking. And the second is the petitioner, being a Japanese national, has recently gotten married to an Indian woman. So if they are more comfortable paying it to the lady, then they can transfer it directly to the lady. I'll leave it to my friend to decide. Both are available.
Let me transfer to you. That's fine. Instead of
Then I'll take it, I'll file an undertaking, your leadership, and then the transfer can be made in my account and I'll transfer it to my client.
But one thing, when the court says something, it has to be followed. You can't have your own submissions contrary to the order. I said, file your objections. Objections have to be on record. If it is not there, whoever has to be there has to appear before the court. That is submission is subject to what the court takes it. But you have an order which has to be complied with. That you should have done it today. Even that also saying that we have complied, though, that also there should be an under. But this I can't appreciate every time. It is submitted with the learned AGA that they're ready to pay the amount of 75,000 to in the name of in the account can transfer the same to the account of the petitions counsel, provided an affidavit is filed before the court. When counsel appearing for the petition submits that, they'll file the affidavit when Wednesday.
In the course of the day.
Huh?
In the course of the day.
File the affidavit in the course of the day. This is the matter tomorrow.
Cell number.
For what?
I have it.
As a direction, not as a recommendation, the efficient respondents and liberty to take suitable action as they. We ask a direction to consider the human
Whatever it is, you have not. Nobody has challenged it. It has to be complied with. Yes. Next.
Number 16, AS Harish.
Listen matter tomorrow. 16.
I'm appearing for the petitioner in this.
Yes,
My lord, I have received a.
Give that. No, not required. Yes, what about this?
My lord, serial number 16. I'm appearing for the petitioner in this. Bank has regularized my instruction or bank has regularized the loan, my lord. We'll produce the document 2 days.
Not required, we'll record it. First of all, regularize the petition's loan account for that a petition.
It has regularized already, my lord.
If they regularize, it is the present
my
petition
instruction
is
are
filed
not
seeking the
followed.
following prayer. Then transfer the petition submits that the account is regularized.
My client has.
Nothing remains for consideration in this petition. Accordingly dismissed as infructious, yes. Because if it is not, I will dismiss it.
No, my lord.
For
Can I have it
accepting
on
such a
tomorrow?
relief.
Tomorrow, my lord. Tomorrow I'll file.
Tomorrow, this is matter
Tomorrow,
tomorrow.
my lord.
Tomorrow, either you get instructions or not, I'll dismiss that petition because such a plea can't be, you cannot seek before the court.
2 days, day after tomorrow, I have to produce the document. Kindly have it on day after tomorrow.
Tomorrow, whatever you want
No,
to
my
do.
lord. Kindly, day
Tomorrow,
after tomorrow.
this is matter tomorrow.
Cell number 17, P Narayanappa, petitioner. SV
The
Girikumar.
petitioner in this matter, my lord, it's of a land is concerned. The respondent number 2 invited applications. Whoever going to purchase the property, half of the amount as a subsidy giving by the respondent number 2. As such, we filed an application. On the application approved by the
Have
respondent
you
number
filed your
2.
objections?
Already he filed. In the last occasion also, again he got an adjournment to file a objection.
Scheme for this to operate under the scheme of who whatever. So that the lady will own the land and she will not sell it and it will be for the purpose of the family. And 15 long years is given to them as a condition that you can have a financial assistance or financial loan in order to develop the land. And the condition is stipulated that you cannot alienate further.
Alienate further is like after till 15 years or forever?
Forever. And now, the has executed a sale agreement with possession, which is illegal and unreasonable. The scheme only gives an opportunity for the development of women.
Please show the clause in the allotment which says that it is not alienable.
Page number 58.
Page number?
28. That is the same.
Where do you get that clause?
First paragraph.
At 28.
ಪರಾಧೀನತೆ ಮಾಡುವುದಿಲ್ಲ ರೈತ ಸ್ವತ್ತು ಕೋಟು ವ್ಯಾಜ್ಯಗಳು ಏನು ಹೇಳುವುದಿಲ್ಲ ಅಂತ ತಕರಾರುಗಳು ಕಂಡು ಕೊಂಡಿಲ್ಲ ಅವರು ನಾವು ನಮ್ಮ ಹಕ್ಕು ಇದ್ದರೆ ಸ್ಥಿರ ಆಸ್ತಿಗಳಿದ್ದರೆ ಬದ್ಧರಾಗಿರ್ತಾರೆ ರೈತ ಸ್ವತ್ತನ ವಯಸ್ಸಂಗ ಯೋಜನೆ ಪ್ರಕಾರ 15 ವರ್ಷ ಕಾಲ ಅಭಿವೃದ್ಧಿ ಸಾಲ ಪಡೆಯುವ ಉದ್ದೇಶಕ್ಕಾಗಿ ಭೂಮಿ ಅಭಿವೃದ್ಧಿ ಬ್ಯಾಂಕಿಗಳಿಂದ ಅಥವಾ ವ್ಯವಸಾಯ ಸೊಸೈಟಿಗಳಿಂದ ಆಗಲೇ ಸಾಲ ಪಡೆಯುವುದಿಲ್ಲ ಯಾವುದೇ ರೀತಿಯಲ್ಲಿ ಖಾಸಗಿ ಮಾರಾಟ ಮಾಡುವ ಹಕ್ಕಿರುವುದಿಲ್ಲ. Clear cut condition which is decided and it is a conditional stated and various documents are being executed as very register.
What do you say about this clause? Whether the clause
My
is
lord,
there or
there
not?
is a specific condition of 15 years. 15 years, not forever. It is,
Not for the alienation. And in the coordinate condition, we was not heard.
Only this part of this part, file a translated copy. Translated copy of only this page number 28.
28.
Yes.
Typed copy.
Translation, I can't read Kannada. File a translated copy of page number 28 alone.
Please.
Yes. This is matter after vacation. The petitioner shall file the translated copy of the sale deed at page number 28.
Cell number 18. Cell number 18. B.V. Badrinath for petitioner.
No representation for the petitioner. This is matter for dismissal. Huh? Let it come tomorrow. Let him be here or else let it come in for dismissal. Yes.
Cell number 19.
For the petitioners, my lord, kindly pass over, my lord.
Judge.
Pass out.
Cell number 20.
Appearing for the petitioner, my lord. There was a order passed by this honorable court on 18/3/2025, my lordships, with an interim order of stay with a condition of payment, and the same has been completely complied, my
Please
lord.
argue on the merits. I will not extend the interim order.
Well,
Argue on the merits of the matter.
definitely, my lord. One more thing, my lord. I wanted to just share the memo calculation additionally. But they have now again put a notice. So basically, last time as per the order, 6 crores had to be paid, my lord. Out of 6 crores, 5%, 5% and 10% had to be paid, totally 20%. And if my lordships can see the
Why should the High Court stay the proceedings when the outstanding is 6 crores by granting 5% of the amount?
No, my lord, but I would like to take you to page number 2 in the
First of
memo.
all, how the writ petition is maintainable against this bank before this court?
My lordships, actually, because I had been doing business in India.
Against this bank, the writ petition is not maintainable. Look at the judgment of the apex court. Give him that citation. This is matter tomorrow. Yes, next. Who? Anyhow, give him the copy. We'll see.
At least,
Yes.
my lord, interim order granted at least can be.
No, tomorrow I'll decide the main writ petition. Yes, next.
21 urgent. Cell number 21 urgent after vacation.
Why is, what did they say? Something they said. What is that?
After vacation.
No, they have said something like, the council, some, huh? They've informed you. Did they inform you? Huh? They sought for adjournment after vacation. And they said it is informed to you, that I've recorded. If you want anything, I can post it tomorrow. Provided it is not informed to you. Any interim order in this? Yes, let it come after vacation. Yes.
Bill number 22, preliminary hearing.
Petitioner, this is week's time I had to file translation copies of some documents as Kannada. Madam.
Give that. What is this?
And the petitioner made representation before the PDO man. The pertaining to him run the clinic in the name of the style of the electro-homeopathy.
To allow the petition to practice in the electropathy, electro-homeopathy without any hassles or harassment. Which respondent?
PDO, seventh respondent, madam.
Huh?
Seventh respondent, madam, the PDO, madam.
Panchayat Development Office.
Please, madam. Issue notice, madam.
What is this prayer? What is this prayer in the, how can the court grant such a direction?
The petitioner made representation before the PDO, madam. The consider my representative, madam, the arrest the.
Then your prayer should be that.
The issue.
What is the prayer? Let us see. And what is the power of this seventh respondent? He is the one who will decide who will practice or who don't practice. Panchayat Development Officer.
Please.
No, let us see in the writ petition, where did he mention about his representation? That the respondent number 3 on 25/11/2003 passed an order bearing number saying that the alternative medicine practitioner shall not prefix the term doctor and practice, and the institution under any state do not grant any degree diploma in the stream of medicine which has not been recommended for recognition. What is how the petition has read himself? Doctor was there. What is that you are doing?
Page number 70, annexed B, the electro-medicine, the medicine of the India, the head office showed the registered certificate, madam. Page number 70, annexed B, madam.
Electro-homeopathic system of medicine.
Please.
This court on in WP number passed an interim order permitting the petitioner to practice without prefixing the word doctor. You have already prefixed it in this writ petition. And also directing the petitioner to strictly follow only their methodology in practice and not any other stream, let alone allopathic.
And the homeopathy is one and the same, madam, the practicing.
No, then you call yourself a doctor. In the writ petition, on that ground, the writ petition has to be dismissed. Then you're coming before the doctor, before this court, and claiming yourself as a doctor.
Kind of 2 days time. And
these kind of writ petitions shall be dismissed with exemplary cause for wasting court's time. This is matter tomorrow. Yes, next, 23.
23.
Press time.
Huh?
Press time.
Why you pray time? Writ petition against Perimal Capital and Housing Finance, writ petition of 2023 has never come up before the court. No notice is ordered. Please come. The present writ petition is filed against Perimal Capital and Housing Finance Limited, which is a private finance company. In the light of the law laid down in the Vishwabharati's case, the writ petition against the private finance company is not maintainable. Accordingly, the writ petition is dismissed, giving liberty to the petition to avail the appropriate remedy in accordance with law. Yes.
Bill
No
number
section
24.
14. It's 24.
Jagatesh Kogi.
I appear for petition. My lords, in terms of my lords, annexure A9, my lords, it could also be my lords disposed of, because there's already a direction to another purchaser, my lords, to approach DRT, my lords. With that liberty, my lords, I may be.
The writ petition is filed. Sing the following prayer.
Page number 121, my lords.
120?
1, my lords.
In respect of, that is in respect of another borrower.
Other flat, my lords.
Huh?
Another flat, my lords.
In respect of another flat, already there is an order directing the petitioner to pursue the remedy to approach the DRT. Accordingly, the remedy is disposed of, giving liberty to the petitioner to have the appropriate remedy within 30 days from the date of receipt of the copy of the order. Petitioner shall have the benefit of section 14 of the limitation.
Highly obliged.
25.
And my lords, IA for dispensation of certified copies.
Yes.
Please.
Appealing for petition, my lord, in this case, my lord, sold the property to respond number 2, measuring 297 square feet, my lord. Whereas
What
now
is questioned before this court?
I am neither the petitioner, neither the borrower nor the guarantor, my lord. Now they have
Fashion
taken,
the vacating notice dated so and so.
yes, my lord, wherein, my lord, well, you can turn to the sale deed, my lord.
One
I have
minute,
sold-
1 minute. Punjab National Bank who appears?
Punjab National Bank.
Look at it, what the panel counsels.
Narayanappa, it seems, my lord. Narayanappa. Narayanappa.
Nagarayappa.
Narayanappa.
Narayanappa. So and so is directed to take notice on behalf of the bank. Then counsel for the petition shall serve the copy of the writ petition and the counsel shall get instructions in this regard. List this matter tomorrow. That's your duty. You serve the papers, then only will.
Please, my lord. Please, my lord.
Yes, tomorrow.
Number 26. Nagaraj
Appearing
Shetty.
for,
Yes.
Lords, a sale is conducted, my lords.
First of all, about the maintainability of the writ petition, then we'll go into the other thing. Bajaj Finance Limited.
Lords, the principal ground on which this challenge is levied is on the ground that the valuation which was initially notified for sale of this very property 6 months back was 2.7 crores.
Mm.
In just about 3-4 months, they reduced it to 1.9 crores and sell the
Why
property.
can't you question it before the DRT?
Lords,
Already questioned?
Yes, yes.
That order
Page
of the DRT
69.
is questioned.
Yes, my lords, that is also under question. But now the principal challenge, my lords, is there was an interim order granted by this honorable court, subject to certain conditions. Had complied with the conditions, notwithstanding, they proceeded with the.
No, this is coming up to a fresh matter.
It's a fresh matter, my lords.
So,
No, I'm speaking about the earlier round of litigation. I'm so sorry, my lords, I have to. In the earlier rounds of litigations, there was a specific order that they should not take precipitative steps upon a condition. 1.3 crores is the total loan amount. 1.6 crores is already paid pursuant to the orders of the court. And for, as on the date when the auction notification was issued, 75 lakhs was already paid, other than 60 lakh rupees which was paid as part of the EMI. So the loan amount which was reflected in the sale notice was not in existence. The total dues was not there. And 2.7 crores is the amount, Vinod, for which they had notified this very property earlier, which they reduced it in.
2 years, we look at the order. That is what is impugned before the court.
Lords, may kindly have a look at page 69.
Yes. I was under the impression directly you have come to the court.
Lords, page 77.
Yes. Hmm. Yes.
Para 17, the applicant is putting forth a contention that NPI classification is not in accordance with law. Respondents had claimed excessive amounts. This contention does not hold good for the reasons. It came out in evidence that the applicant had availed moratorium and reschedulement of the facility, and despite the same, repayments were not made as contended by the respondents. This view is taken in the absence of any proof, as the so claimed prompt payment is put forth by the applicant. Applicant is impugning the measures alleging undervaluation. In support of the same, applicant has belatedly produced a valuation secured at the time of sanctioning of the facility. Even though applicant is harping on the alleged undervaluation, the tribunal is not inclined to accept the said contention. There is no consideration, my lords. We had produced the valuation as on the date when this facility was extended.
Where is the document? What is the?
That document, my lords, unfortunately, I had asked them. They had not produced, made it as a part of the records. Lords, may have this matter tomorrow, my lords. I'll ask them to file it along with the. My apologies, my lords. I had just asked them.
What was it as on the date of
2.7 crores.
And what was it as on the day the property was put to auction?
Please, 1.9. Very well, lords.
Yes.
Grateful, lords.
Then number 27. HS Prashant.
Yes.
Lords,
HS Prashant.
the one-time settlement offer has been rejected, my lords. After, your lords may kindly take the,
No, can this court pass orders on that, whether in
I
one-time
understand,
settlement?
my lord, these are all purely commercial decisions which will be taken by the bank is the view expressed by the Supreme Court.
Yes.
There's no difficulty about it.
Then it
Lords-
says issue to quash the e-auction sale notice, to accept
Lords,
amount
now,
as per the OTS
Lords, it is
proposal.
something like this, my lords. Can I just persuade your lordships? May? Lords, when we go for a OTS, this is one difficulty which we are facing. I will say that initially we said 12 crore rupees, considering the valuation. Then they said that no, you'll have to increase. We went up to 15. 15 offer was accepted by the regional manager here, saying that subject to approval by the competent authority, your offer at 15 crores is accepted. So we paid that 10% amount. Then it appears the matter has gone to the competent authority. Competent authority says, no, it is not accepted. 15 crores is not acceptable. But they will have some formula. But now if I go for a one-time settlement, if they say it is not 15, according to the formula which we have, some yardstick which they have, you'll have to pay 17 crores, 18 crores. They come out with that. If they can match it, okay, I'll match it. If I can't match it, then I have no option, my lords, but to
Ultimately, what is
something.
proposal you have to give, isn't it?
Some
You will not accept what they say. And
considered.
And you are ready to, you have given the proposal for what is the amount? Huh? No, what I'm saying is, somebody says, I'm ready for a OTS proposal of this amount. We will give you OTS proposal on this amount, but not the amount which you are quoting. That would be the way, not just simply saying, oh, what you have given, this is the amount, we will not. If OTS proposal is in place, you can say that on this amount we are agreeable. That is in the interest of you also.
It can't be. It's a one-time settlement offer.
What will they do? No, let the court understand what they will do. That's what OTS amount.
That particular money will be every 4 hours, bank is already indicating the money which I have to pay, and on that basis, we
Oh, the party can say 101 things. But it is a OTS that the court understands and everybody understands. That party can put it any way they want. But it's no, when they are coming forward, you say you can indicate your amount. Yes, get instructions when you want.
As a matter of fact, orally they said 15 crores. We matched that 15 crores and paid the money. After they accepted my one-time settlement, they said that it will be subject to the competent authority accepting this. Now I get an endorsement saying that competent authority is not accepting it. Together with that comes the sale notice.
So without the competent authority's approval, who are you to say that it is 15 crores?
It is still like the sale. Yeah.
I think most people, I think so far we have not put the property in auction. The first time I'm putting the property, in case it is get paid, then only I think as per the bank norms, I can put the proposal to make profit.
So is it your submission that without a sale, without even one sale, there can't be a proposal for OTS? Then why did you give in his case initially, saying that 15 crores?
It's annexure A. In view of the above, we regret to inform that OTS proposal is rejected and request you to improve your offer. That is the endorsement, not that.
This is how what bank says it all varies from case to case, party to party. No, not at all. So then I'll take whatever that you have stated. So without even putting the property to sale once, why did the OTS offer is considered and said that that is not acceptable because it's so and so amount is quoted? Look at it, but I'm going to pass this order. Yes.
Please.
Give it to the please sir.
I shall.
Mr. Vignesh Shetty submits his instructions to appear. Let's this matter tomorrow.
Please.
Till number 28.
Yes.
May it please your lordship.
Yes, Mr. Vignesh,
Miller,
how about,
may-
how happy you feel to make submissions like today, one submission you paid. And no. Unfortunately, all these submissions, no. No, I'm saying it is so embarrassing for the advocate to make submissions on a rule and which you don't follow. And tomorrow in other case, you say that it is Reserve Bank guidelines which you don't follow.
Because I thought that somebody will try to say the property since they have not concluded. That's the one reason that I give. Apart from that, what is one that I give?
Don't take it personally. It's not you. It is like your action of the bank. Your action of the bank I'm referring to. You will say something legally which you don't follow. Then there will be contradiction between the two. Yes.
Lots of so great.
Number 28.
Millers, may it please your lordship. Millers, this is a very hard case where because of the vendetta of the bank manager, I have been made a defaulter. Millers, I approached the bank in Baswani branch for 3.65 crores for establishing a daily development board, a cow, what is it called? Cow grazing unit.
Why should we interfere with the 30?
No, Millers, your lordship may just hear me for 2 minutes to see the malafide behind this. Otherwise, I wouldn't have been before your lordship. Millets, the fact of the matter is 3.65 crores I would put. The National Dairy Development Board, which is supporting me, is going to put 2 crores. Already 50 lakhs has been released. This is for a noble cause. Millets, at my elderly age, I have tried to do something noble for the society by bringing out this cow grazing unit. Millets, then what happened? They only released 1.25 crores. I kept requesting them to release the remaining amount, which they never did. When they didn't do it, I put my money from elsewhere. I made arrangements and did it. And only thing that I asked them was that this 1.25 crores which I have taken, give me EMIs. I will repay it. I am not defaulting. I am putting from time to time, Millers, the chartered accountant statement also I have given. Millers, what they do, I have 2 other loans where 18 crores of my property is with them, which is for 50 lakhs and 99 lakhs for home improvement and other things. I have some other business also. They club all 3 of them. Then they make an EMI for the 3.65 crores and say, now you have defaulted the EMI on the entire amount, which I have foregone. I said, I don't want the loan because you're not giving me. Millers, nowhere I'm a defaulter. Millers, they then backdate the surfacey notice, which is the most shocking aspect of it, 10/3/2025, and issue a notice to take physical possession of my property, freeze both my bank accounts of the Koramangala branch. Millers, where am I to go in such scenarios where bank is taking vendetta against me? I am not a defaulter. If I was a defaulter of any kind, Millers, I wouldn't be knocking at this, Your Honorable Court for Justice.
13 notice is given on 10/3/2025.
No, it is of 26, which is backdated as 25.
Then where is your response to that?
Yes, Millers. Kindly see my reply. My reply is on page. Just tell me the page. Millers, I had to make police complaint also. I had made police complaint to the DGP saying that he wants some extra gratification. Now kindly see in this annexure H.
Page number?
Page number is 74. Your notice dated so and so of 10/3/2025. Where is the correction of the date? This is the content about our notice does not reflect the true facts and the issues, fabricated, false, hyped and misleading to project me as a defaulter with the sole intention to harass me by the zonal manager through your branch. Straight away I have taken the bull by the horns. Loan against my house for 99.5 lakhs sanctioned by so and so.
Who appears for the Indian Bank? Vignesh Shetty appears.
I only need small protection.
No. Without instruction from the bank, I'll not pass any interim orders. I'll have it tomorrow.
Tomorrow,
Please serve the
very
papers
well.
on the bank council. Mr. Vignesh Shetty is directed to take. Is he the one appearing or any other advocate?
Indian Bank, he is not there.
He's not there.
Indian Bank, TP
Muttanna is there. Mr. Muttanna is directed to take notice on behalf of the respondent bank. Will counsel the petition, serve the copy of the writ petition, and the council shall get instructions by tomorrow. This is a matter tomorrow.
Much obliged.
29. Venkita Raman.
Yeah, my lord, for the petitioner,
This is a gross undervaluation of the property.
Yes.
And the case is not adjudicated in DRT. It became infructuous because they withdrawn
What is
sale.
questioned before this court?
My lord, you know,
What is
the
questioned before this court?
IOTOP cases of Apex Court give the ground for,
During the fixation of reserve for a fixed price, so and so.
yes,
In the alternative, when permitted to approach the DRT and the Supreme Court have to consider the petitioner
yeah.
claim on merits. What is this prayer?
My lord, if the, my
What is
lord,
the-
if
what is
if
the
lordship is
present-
inclined to relegate me to DRT, the limitation may be protected.
No, limitation, how it will be protected. Today, the matter is coming up before the court.
Oh, my lord, yes.
So you can't do, because you have no limitation to approach, you can't come to the court and seek
My
your
lord,
liberty.
the-
So what is the present stage of the proceedings?
My lord, I am not challenging the sale. Sale is already affected. But the undervaluation is there. 1.4 crore is the government value itself, which they sold it for 64
When
lakhs.
they issued a sale notice contain all these things.
Yes.
Then, from the date of the sale notice, you have a limitation to go before the DRT.
Correct.
When was the sale notice?
That sale notice is challenged. I mean, the first sale notice has been challenged before DRT, which became infructuous because they bank withdrawn that sale notice and it became infructuous. So it was not adjudicated on merits.
Then what is the next benefit?
Next sale notice has not been challenged because of the medical condition of the borrower, because of the psychiatric conditions. And I have
We
mentioned,
can't give you that liberty at all.
my lord, I couldn't able to challenge, and later I understood the valuation of the property is very, you know, the Apex Court has given the ground, you know, as a recognized for the undervaluation, this is a ground in IOTA of cases,
But
my
you
lord.
can't have it directly, you can't have it indirectly also.
At least, my lord, you know, a humble prayer is relegate me to DRT to hear the
You
matter.
go to DRT, but I'll not give you any.
I'm not challenging the sale, madam.
Without
Only undervaluation
challenging-
I am
without
challenging.
challenging the sale, that is not a step. Fixing the amount is not in a measure which you can question before the DRT. You have to question the sale notice, then only you can question this.
My lord, understand there is limitation, may be relegated with the limitation protection, please.
No protection. I can only give you liberty provide in accordance with law.
Yes, my medical condition, I have given the,
From
you know,
that you tell the DRT. You can, when the DRT has no power to do it, why should this court tell the DRT to do it?
because
The
the case is not adjudicated, my lord.
You have not gone to the DRT. How will it be adjudicated? The writ petition is filed saying the following prayer. When counsel of the petitioner submits that he is not aggrieved by the sale, but aggrieved by the amount that is fixed by the DRT by undervaluing the property of the petitioner.
Even government value
Hence,
is
the petitioner
1.4
has
CR.
come before this court, questioning the said action of the bank, and also in the alternative, you may permit it to approach the debt recovery tribunal. For approaching the debt recovery tribunal, the petitioner has to question the measures that are initiated by the bank. And the measure is the sale of the property. And in the auction notice, an amount that is fixed by the respondents. But the petitioner submits that. He is not questioning the sale notice. In these circumstances, if the petitioner has a remedy, this court cannot entertain the writ petition. If the petitioner has a remedy before the DRT, he is at liberty to do so in accordance with law.
Limitation may be protected.
No.
Small indent.
Memo we wanted to file with the chartered accountant statements of all the bank accounts.
28.
Your lordship will look at it before tomorrow. That's
Give it to him, give it to the other side also. Take that in the earlier matter. Yes, next.
Cell number 30. Cell number 30.
Yes.
Your Lordship, we're before this honorable court, even before a possession notice is
LIC
issued.
housing finance writ petition is not maintainable.
Your Lordship, there
They
are
have to
some
go before the
judgments on
DRT.
that issue that it would still be
It
maintainable.
is settled. It is settled by the judgment of the Supreme Court.
Your Lordship, in this very matter, Your Lordship, with the very same issue, it has already been settled in another matter, Your Lordship, which I have enclosed.
What is that? I didn't understand.
There are two loans. One has
No,
already
that's
been
true.
settled.
First of all, I am on the point against LIC housing finance.
On the
Limited.
maintainability, I understand, Your Lordship.
In the light of Vishwabharati's case, it is not maintainable against the private finance company.
Please, Your Lordship, might I show that there would be an amount of state in this?
Because that's a uniform, the. approach
Kindly
this
have
court
it
has
tomorrow,
had.
Your Lordship. I'll bring those judgments.
Huh?
Kindly have it tomorrow. I'll bring those judgments on May 10.
I have so far, relegated at least 100 matters to the DRT on this ground.
I understand,
So
Your Lordship.
Tomorrow,
Tomorrow,
both the
kindly.
Shobha's judgment and Vishwabharati.
Please.
Give that
No,
citation.
Mishbharti, we have, Your Lordship. I shall attempt to please.
Shobha also, yes.
Cell number 31 to 33 are
Shobha arising out of Muthoot Finance. Straightly applies to your case.
31 to 33 ordered. Cell number 34. Party in person. Nominee name.
Petitioner present, Your Honor. Petitioner present. Your Honor, the stage is for them to produce.
1 minute, 1 minute. By the next date of hearing, respondent number 1 to 4, who represents? You represent, shall file the present status report with regard to this case. Further, respondent number 5 and also the implead applicant shall file their objections. Who represent 5? Have you filed your, huh?
No.
No, when I said on the last occasion,
Yes.
then you should have stated so.
No, counsel, kindly, I
The
have
implead
asked you to
applicant
take
shall
a
file their
certified
object. Who
copy.
is the implead applicant? Their objections by the next date of hearing. If objections are not filed by the next date of hearing, right to file objection shall be forfeited. I can't
Yes.
help it now.
Yes, Your Honor, because
Yes.
he's not a necessary party also to this suit. He's not a
Where is the status report?
May I have a copy of it?
Have you served on that?
No. No, Your Honor, may I have a copy of this report? And the investigation is botched, Your Honor, and it is defunct because they have been colluding with the MSR hospital, and they have been forging and causing a lot of mayhem in this investigation, and hence part of this prayer is to take away the investigation from Sadashiva Nagar police station and give it to a neutral agency. Your Honor, I'm not even being given a copy of the report being submitted. Investigation is not underway. Investigation has been halted. They have not proceeded. Magistrate has clearly said to hand over the investigation to KMC for preliminary inquiry because of statutory laws laid out by the Karnataka government and by Apex Court, Jacob Matthew and Lalita Kumari case. Your Honor, for 9 years, they have been staying the matter. Because of this magistrate order, I have come to this honorable court with clean hands asking for the implementation of this honorable court, magistrate order, which is twofold. One, magistrate has clearly mentioned that they hand over the investigation to CID. Okay, according to CRPC 156(3), okay, it was not allowed. So this honorable court under criminal petition has taken out part of the order. But the second fold of the order is to hand over the investigation to KMC because medical negligence has to be given to the preliminary inquiry body, that is KMC. Your Honor, today they have delayed this whole report, and even I'm not being served a copy of this. Mr. Nandakumar is not party to this suit, and no prejudice will be done even if he is not part of this suit. Why? Because preliminary inquiry is still not conducted, Your Honor. It
My
is
lord,
not
I appear
true.
for
It is false. It
Karnataka
is
Medical
false.
Council in this matter, my lord.
Yes.
It is false to say that investigation is underway.
You have filed your objections?
My lord,
No.
I seek one small adjournment, my lord, because the registrar who has to sign the affidavit has
Why
gone
he's
to
waiting
appear.
from 2018 to sign it?
My lords.
No,
if
my lord,
lords
this has
permit
come
me
only
to
last
submit.
occasion, my lord.
Huh?
This to file with the affidavit was only directed previous, last to last hearing, my lord. In fact, we had invited the petitioners also to the medical council to provide some documents and also the interim order granted by this honorable court to verify those things. And after drafting that objections, the registrar of the medical council has traveled to another high court, my lord, another bench. Therefore, there has been short accommodation I am seeking, my lord. Even if the matter is taken up on Friday, we will do the needful, my lord.
Your Lordship, my client is present over here and she's
Medical
suffering
Council of
from
India
HIV.
seeks time to file his
9 years.
objections. It is submitted that the objections are ready. List this matter on 4th of June.
Obliged.
Obliged, my lord.
No, certified copies may be obtained, Your Lordship. Certified copies, they give it in 1 week's time. Your-
Huh?
Your Lordship, kindly,
Status
may I
report is
receive a
filed by
copy
the
of this report
respondent.
being submitted, Your
We'll see whether that has to be served to you or not. Yes.
Cell number 35.
Obliged.
Cell number 35.
35, I seek password, my lord.
I'll seek a pass.
Pass. 36.
Cell number 36. 36.
36, I appear for the respondent number 2, my lords.
Come here, please.
Petitioner's
No representation.
application has been rejected for limitation, my
No
lords.
representation. Is this matter for dismissal tomorrow? Yes, 38.
37 adjourned. Cell number 38.
Okay, for the petition.
Cell number
We have
38.
case kindly up next week, my lords.
38.
Family function.
Yes. Yes, Mr. AGA.
KL
Is this
Srinivas.
matter after vacation?
Interim order may be extended, my lords.
Interim order earlier granted is extended. 39.
Cell number 39. Cell number 39. Suresh Kumar Acharya.
After vacation.
Please, my lord.
Cell number 40.
You are ready
Not ready after vacation.
Lordship of the defendants, kindly.
after vacation.
Cell number 40.
For the petitioners in this matter, my lord, I'm challenging the annexure Q and X, my lord, as seeking a mandamus and quashing of the
Let's see.
annexure Q and X.
Where is the relief?
May I be permitted to submit the facts, my lord?
Quash the letter
Please, my lord, Q and X, my.
upon it. Director General, Quality Assurance, Ministry of Defence, to convey the decision of the fifth respondent. What is this? Where is that letter?
My lord.
There are so many pairs.
3 pairs, my lord. I'm seeking direction to quash the
Who appeals to the respondent?
X.
Kumar MN.
Please, my.
He is representing the Union
Please,
of
ma'am.
India. Where is he? You have an interim order?
Yeah, please, my lord. No, my.
No representation for the respondents. Interim order granted earlier is extended until further orders.
Interim.
This is matter after vacation. Yes, next.
My lord, first week of June, my lord.
Yes, next.
Cell number 41. Anand Muttalli. AGA. SP Darshan.
Number 38, my lord. Here.
38.
Any interim order in this? No interim order. This is matter after vacation. No representation on behalf of the petitioner. Yes, 42.
42. Cell number 42.
Petitioner.
CV Manjunath.
This is the petition for the respondents.
This is the one you're saying that it can be disposed
Yes,
of.
ma'am.
This is
Not to farm the road in the private land belongs to the
Vidya Devi
petitioner.
versus state of Himachal Pradesh.
Huh?
Vidya Devi versus state of Himachal Pradesh. Where the Vidya Devi versus state of Himachal Pradesh. The formulation is that, you know, if the state wants to form the road, the state wants to form the road, let them acquire and do compensation and
Yes. It has
form the
not-
road, if at all.
They have not been done so, my lord, without there being any acquisition proposal or anything.
See, let us see.
Please.
Let us see. What is the prayer you saw?
My lord, prayer is at page number 17, my lord.
To issue a writ of mandamus
Please,
directing
madam.
respondent 1 to 4 to consider the representation dated 3/10/2020 of the petitioner, requesting respondent 1 to 4 to stop from illegally forming road of the land of the petitioner due process of law. Now, what are your instructions? You have not laid the road so far.
My instruction is that it's not a private land, it's a government land. That is my
Whether you have
instruction.
laid the road or not is a question now.
No, it's not yet.
So please consider that, pass orders and
Yes,
then
madam.
lay the road.
Yes, madam.
The present writ petition is filed, seeking the following prayer. It is a case of the writ petitioner that petitioner is the absolute owner of survey number 311, an extent of 4 acres 20 guntas, with carab of 1 acre 16 guntas, and land in survey number 309 of an extent of 4 acres 7 guntas, with carab of 1 acre 4 guntas. What is it? Ammani, Paira Sagara village,
Correct.
Kasba Hobli, Tudi Bande Taluk, which the petitioner has acquired by virtue of a will executed by his mother, dated 10/5/2002. Subsequent to the death of his mother, the petitioner has become the absolute owner of the property and all the revenue records are mutated in the name of the petitioner. It is a grievance of the petitioner that respondents want to lay a road and without even acquiring the land of the petitioner, without following the due process of law, the respondents are laying down the road in the petitioner's land. And he has given a representation to the respondents
Annexure G, madam.
on Which respondent?
To the response number 3 to 4, my lord.
3 to 4?
Yes,
3 and 4 on 3/10/2022, stating that they cannot lay the road in the petitioner's land. And as the same was not considered and they are proceeding with the laying of the road, the petition has come before the court. Learned AGA appearing on behalf of the respondent submits that the land belongs to the government, it is not the petitioner's land. Further, they have not laid the road so far, next part, considering the submission made by the learned AGA and the fact that a representative that the road is not laid so far. This court deems it appropriate to pass the following order. The writ petition is disposed of, directing the respondents to consider the representation dated 3/10/2022 in accordance with law within a period of 4 weeks from the date of receipt of the copy of the order till such time that the respondent shall not lay the road in the petitioner's land.
Without due process of law or acquisition of the property.
Without the due process of law.
Grateful.
Number 43.
One submission, my lords, with respect to serial number 41.
41.
Please, my lords. My lords, I represent respondent number 2 in this matter. The name was reflected wrongly in that. Lords, in that particular order, we had challenged it in writ petition number 17842.
What had happened to 41?
After vacation, no
Yes,
representation.
it's posted after vacation.
After
Petitioner was
vacation,
not
because it's
there.
not maintainable because there is a stay which is operating in that particular proceedings.
This is matter tomorrow. No, as there is no representation on behalf of the petitioner. List is matter. Is it there is no representation? List is matter for dismissal tomorrow. Tomorrow you can submit.
Grateful, my lords.
What is your name?
JP Darshan, my lords.
Write on the paper. The name of the respondent number 2 shall be correctly printed as, shall be shown in the cause list as. So take that name and write. Yes.
Grateful, my
Number
lords.
43. Court Arjun Ram.
Yes, 43.
Respondent.
What is this?
Senior citizen.
Senior citizen. No representation on behalf of the petition. This is matter after vacation.
Serial
Yes.
number 44. Serial number 44.
My lord, there has been a subsequent notification
Lord, kindly
regarding.
pass on.
Come here.
I'll make some.
When I'm asking her, she says that I'm not posting anything without any this thing. You ask her why all this matters are listed. No memo, it is here. There is no memo. Where is the memo? Huh? What order listing of 2020? No, just all that is not necessary. Ask her on what reason all these matters are listed. Yes. Which
Serial
one?
number 44.
44 kindly pass on, my lord.
Part 40?
Pass on. Small pass on.
Post it tomorrow.
No, 44.
44 you are
4
asking.
pass on.
44 password, yes.
Serial number 45. DC. Prabhakar.
My lord, in this case, we have challenged the annexure N, which has been passed by the authority. Your lordship may kindly come to 117. Unfortunately, it is in Kannada. May I produce the English version of that, my lord?
This is matter after vacation. Look at it if interim order is there extra. Next 45.
Serial number 45. After that.
Interim order is
46. Disposed. 47.
47. The endorsement was issued stating that a matter is pending before the Honorable Apex Court. The status reveals, my lord, the matter is still pending. I request the matter to be taken after vacation, my lord.
After vacation.
Serial number 46, they didn't inform for the respondent side, my lordship.
Disposed. Dismissed.
It is disposed.
This was grateful, my lordship, grateful.
Yes,
Serial number 48.
Order may kindly be taken after vacation.
What?
it's after vacation.
Serial number 49.
I appearing for the respondents, my lord.
No representation on behalf of the petitioner. Wherever there is no representation, don't extend the interim order after vacation.
Serial number 50. Serial number 50. Rajan
What's
Rai.
up, lady?
My lord.
Kindly
I
brace for
have
time.
filed my
Lordship.
objection statement and
Take
also
the-
I have filed an.
This is matter after vacation. Yes, 51.
Serial number 51.
Interim order is there. Interim order all your
And they have not complied with the interim order, my lord. Therefore,
take
they are
instruction
not
about
entitled for.
How are you entitled?
Yes.
No, in the last date, in the.
No,
auction,
they have
last
not
date
paid.
is there.
Only 8 lakhs out of 11 lakhs they have come paid.
I'll take instructions. Lordship.
Interim order, it is submitted that the interim order granted by this court is not complied with.
Yes, my lord.
Hence, the interim order is vacated. Is this matter after vacation? Yes, next.
Bill number 51.
51, my lord, the state has to pay, my lord, the admitted amount of 28 lakhs. I have completed the work. There is no dispute with regard to the completion. They themselves have given a certificate.
When is that?
My lord,
Not about completion of work, about this amount is due.
yes, my lord. Please, my lord, please come to my lord, 95, page number 97. Your lordship will get it at 98, my lord.
Is it correct, Mr. Ajay?
There is no dispute with regard to that, my lord.
Is it an admitted amount?
Even
only-
in page number 98 also they have admitted, page number 102 also they have admitted.
Just look at this file. Pass over. Yes.
Bill number 52. Satish K. 52 Satish K.
But I pay for the.
Yes.
Your lordship.
What is the prayer?
But next year, it is in all the documents are, my lord. Page 130 is the impugned order.
Call for records from respondent in respect of the impugned order dated 27/10. Who passed the order?
But the first respondent government has passed the impugned order. But I was working as my lord sub-registrar. I have allegation is, my lord, I have collected deficit stamp duty while registering certain document. For that, my lord, direction is issued to my lord, launch a criminal prosecution. That may not be, my lord. They have a.
Have you filed your objection?
I have not filed objections, my lord, and this may not have any direct impact on him because it's a internal correspondence. Once the criminal prosecution is launched, he is at liberty to challenge that. He may not seek this remedy before your lordship.
Assuming for a moment.
Not given to you.
Please, please.
This copy, you notice no such decision is taken now.
It's only internal
But
correspondence.
there is a direction to give launch a criminal prosecution. Positive direction is issued by the state government.
Respondents shall file their objections by the next date of hearing. The interim order earlier granted is extended. Let's just matter after vacation. Yes, 54.
53 urgent. 54. Bill number 54. Manohara N for petitioner.
Yes, what is this?
Lordship,
What is the petition about?
this, my lord, government has not filed any objections so far.
The writ quashing the notice dated 28/20/23.
Yes.
What is the notice?
Notice is issued under Metrology Act, my lord.
What it says, let's read the notice.
Page 13, my lord, kindly see,
For the
page,
following
page
violation,
13,
writ package.
point number 2, section 36 on a penalty for selling of so and so is 5,000 rupees, but manufacturing is 25,000 per. We are only, we are only wholesale dealer, my lord, not a manufacturer.
This is a notice to compound this offense.
Yes, my lord. And we are given reply to the Shoka's notice. And the
Objection.
compounding offenses, my lord, they are not,
I can make submission.
wrongly they
Make
are
submission.
issued.
It's only notice, my lord. Once they give a reply.
Notice, it says, failing which it will, they have decided that he has committed an offense.
Yes, my
And
lord.
they've asked him to pay the compounding fees.
Yes, my lord. If
That is an
not,
order.
if not, my lord, what happens? Thereafter, a complaint will be filed before the learned magistrate under section 200 of the CRPC. Then the magistrate will take a cognizance based on this notice. Then they are entitled to challenge. It's only a notice.
It's not a notice, you have decided that he has committed an offense.
It's a compoundable notice.
Correct, because he had committed an offense.
Since there is an
You
my
please
lord.
pay the fees and compound the offense.
If not, we will file a complaint before the magistrate. We will not take any action based on this notice. We will
Now,
file.
what is, let us look at that.
Yes, my lord. Kindly take that.
What is
Legal
the tax
Metrology
called?
Act, Legal Metrology Act, my lord.
Hmm. Which provision? This is given under which provision?
48, my lord. 48, section 48,
Let's see, 48.
compounding of offences. Any offence punishable under section 25, 27, so and so, come non-payment of credit for government, so and so, my lord.
So the entire act deals with regard to the penalty. Where do you get the hearing?
Should kindly see annexure B, my lord. Provision, section 36, my lord, they have imposed.
Let's see 36.
36. the said-
Penalty for selling etc. of
Yes.
non-standard
The said
packages.
person prohibited to pre-pack and cause or permit to be pre-packed the above commodity without compliance of the rule 2, rule 6(1)(b), rule section 36(1), the common generic names of the commodity and the name and number or quality of each product is not marked. Rule 6(1)(c), section 36(1), the net quantity is not marked, is standard units.
No, under the act, what is the procedure? And what procedure the respondents have failed to follow? That you have to show. What is the procedure? Before determining that there is any violation of the provisions of the act, any notice is contemplated.
Yes.
If you look at as I look at it,
Yes.
nothing is contemplated.
Yes.
It straight away speaks about the penalty and it's a compounding phase. Now, you are not acceptable for the compounding of the same.
Yes.
Then it will go before the court. And there you will get an opportunity to say that you are not liable.
My lord, as per this section 48, they
Let's
what
read
issued
that.
a notice, for that I have replied.
Let's see where does it say compounding of offences?
Compounding,
Yes.
page 13, my lord, kindly
So
see,
read the provision.
offences, chart they have issued,
offence
they have given a
punishable-
chart, my lord,
Huh?
chart,
That
page
I have
13.
seen. Let's see the section full what it says. Any offence punishable under section so and so.
Yes.
Credit to the government of such a as may be prescribed. Where do you get the notice here? That's what I'm saying. Now, when you're filing a writ petition before the court, you have to show that there is some action, the action on the part of the respondent is contrary to the act or against principles of natural justice. So what is contemplated under the act, what is not followed by them? Password?
Kindly have it tomorrow, my lord, tomorrow, please.
Yes. Who asked you to, all that? Only date matters are asked to be listed. Yes. We'll see tomorrow, come to the same. Yes.
Serial number 55,
Appearing for petitioner in this case.
Rahul
Covered
P.
by this judgment, my lord. At least covered by this judgment, similar matter.
Take that.
The question involved is whether the petitioner, which is a Nirmiti Kendra, falls within the definition of a public authority as defined under section 2H. Lord, the coordinate bench in WP number 52581 of 2017, my lord, has held that they fall within the definition of the public authority and they are covered under RTI Act. Therefore, my lord, this petition virtually goes, my lord. This requires to be rejected.
The writ petition is filed, seeking the following prayer. It is a case of the writ petitioner that the first respondent has passed the impugned order against the petitioner, directing the petitioner to provide information and documents sought by the third respondent as public information officer and the Right to Information Act. According to the petitioner is not a public authority as defined under section. Is not a public authority as defined under the Right to Information Act. And he has relied on an order. It is stated that one Nirmiti Kendra of Chitradurga had approached the court in similar case in WP number 52581 of 2017. And the same was stated. Basing on that, an interim order is passed in this case. When counsel for the petitioner has placed before the court the order that's passed in WP number 52581 of 2017, it is 6 August 2025, where the coordinate bench of this court has considered and held that the PIO and the project director Nirmiti Kendra falls under the public authority and is amenable to the Right to Information Act in the light of the order dated 6 August 2025, passed in WP number 52581 of 2017. Not the writ petition is dismissed.
Grateful, my lord.
This writ petition, in case of the PIO, the project director Nirmita Kendra, PIO and the project director versus the State Information Commissioner. Citation.
My lord, this is the same judgment which is applicable to the other case. 2 days back, lordship for hearing, release institutions, Nirmiti the grant. This is
Also keep this judgment. Yes. Dismissed. Yes, next.
Serial number 56. Serial number 56. Kiran Kumar K.
No representation. Let's just matter after vacation. Don't extend the interim order even if it is there. Yes,
Serial number
57.
57. Naveed Ahmed. 57. Naveed Ahmed.
What is this? Somebody has moved the memo and they don't appear. Who moved the memo? See? Then why are they moving and not appearing? Give that. What did he say in the memo? Though the respondent counsel has moved the court, there is no representation on their behalf. This is matter after vacation. Yes, 58.
Serial number 58.
My lord, serial number 58, I appear for the petitioner in this matter. I have filed memo for withdrawal, please. My lord, the matter has become infructuous. To that effect, appropriate orders may kindly be passed.
Where is the memo?
My lord, today morning I have filed it, please, my lords, at the count.
Lord, I had filed a memo 1.5 years ago.
For what?
Same reason.
The memo, both the council submit that. The writ petition has become infructuous, accordingly dismissed as infructuous. Yes,
Grateful, my
59.
lords.
And for the petitioner, my lords.
Yes.
Sir, appearing for the respondent bank, my lord, I'll file my objections during the course of the day, my lord.
My lords, the last occasion also remained same submission, my lords.
That's the matter tomorrow, the
Grateful,
request of
ma'am.
council to the bank. Yes, 60.
60. Prakash HKV.
And for the respondent, because the posture notice has been challenged last year, my lord. They compared the interim order
Subsequent to that, my lord, not a single rupee has been paid.
Lordship, I have taken the loan of rupees 20 lakhs. 19 lakhs 83,000. Out of that, almost all 11.70.
It's outstanding as on today.
As on today, my lord, 32 lakh 42,000. They have paid 5 lakhs as per the court direction. Subsequent to that, my lord, not a single rupee.
Lordship,
Now the problem is after you take the loan, that amount will not be the same. Every day, every month, the interest will accrue.
I'll come to point. I have taken the total loan 19.
That we can't consider. I'll not go into how much you have taken,
Lordship.
what is that.
Term is 30 years, Lordship.
Whatever it is. If
10 years started, 10 years started completed. Within that time, I have paid 20 lakhs rupees, Lordship.
Go to the tribunal and question all this. We can't keep the matter pending.
Just a moment. Annexure E, Lordship.
You will have if you have an interim order, you will have the benefit of it for another 4 weeks. Go to the tribunal.
I have complied. Lordship.
Not complied with.
Lordship, page number 30, Lordship. Just a moment. His mother was expired. He was blind. He is not able to do all the as per. Hence, it is referred to mediation.
It may refer to the mediation.
Page number 30. Yes. Page number 30, Lordship.
We'll refer it. We'll see what happens.
Lordship, just a moment. Page number 30, Lordship.
Go approach the bank
Even
itself.
if I see all that, I can't help you. That's what you have to understand.
Refer them to the mediation or something.
The matter.
Let them seek liberty, my lord, or let them directly go approach the bank itself.
The petition submitted to the matter may refer to the mediation. The party shall appear before the mediation center on what date?
After vacation.
Mediation center on 4th. Interim order earlier granted is extended.
My lordship may give a date, my lord, to report back. 6th. To report back before the court, the date may be fixed, my lord.
Yes, and it shall be reported, any settlement or otherwise shall be reported back to this court by 17th of June.
Much obliged.
Yes, next.
Petition number 61.
My lords, in this matter, I'm appearing on behalf of the petitioner, my lords. This is a matter which is, the essay is dismissed on the limitation, my lords. However, my lords, kindly see page number 83, my lords. A writ petition was filed in that operative portion. My lords, is at 89, my lords. Paragraph number 10. Needless to state that while considering the aspect of limitation in the event of the proceedings are initiated before the DRT, time spent before the court may be taken note appropriately. Notwithstanding this, my lords, my essay is dismissed, my lords. So that has to be remanded, my lord, is to go back, my lord.
No, we have to understand first how it is considered by the court. Come to the order.
Please, my lords. At page number, operative portion.
For that, the dates are required. When did you go before the DRT? When did you come before the court? What is the action that is questioned before the DRT? So, what is questioned before the DRT?
After the disposal of the writ petition, my lords, immediately I have approached the DRT.
That is not, the court only give you the limitation as far as the time spent before the court, not before that. So,
please, my lords.
What is the step you are questioning? What is the
Sale
measure?
certificate was questioned, my
Sale
lords.
certificate dated.
Five three 2025 Lakshmi. 5/3/2025. 5/3/2025.
5/3/2025.
When is the writ petition filed? WP of 2025. When is it filed?
Filed, my lords.
That is what is required, the specific dates.
I shall ascertain, my lords. Kindly have this matter tomorrow, my lords.
Yes, tomorrow.
Obliged. 62.
Respondent, my lord. The petitioner in this
Section 14
matter.
order has been challenged. Karnataka Bank, my lord. Private sector bank.
My lord, one submission. Necessary orders may be passed. Liberty may be granted to approach.
Have no interim order.
No interim order,
But
nothing as
direction
such
has been
process.
given to undertaking, file an undertaking affidavit. That
The
also
writ
they are not
petition is
done.
filed seeking the following prayer. The writ petition filed against Karnataka Bank Limited in the light of the law laid down by the coordinate bench of this court in Gautam versus so. The writ petition against Karnataka Bank is not maintainable. Accordingly, the writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy before the DRT within 30 days from the date of receipt of the copy of the order. Petitioner shall have the benefit of section 14.
Obliged.
Grateful, my lords.
63 adjourned. Petition number 64, parted matter. Girish Arjun for petitioner.
Let's see, what is this parted? The matter is listed today before this court under the caption Part Third. No representation on behalf of both the parties. Delete this matter from the caption Part Third, posted before the court having roster after vacation. Yes,
Cell number 65 adjourned. Cell number 66. Cell number 66.
Lord, appear for the respondent.
Kalyana.
Lord, I've entered appearance this Saturday. Seek an adjournment. It's vacation.
this is matter after vacation, and by the next date of hearing, the medical counsel shall file their objections,
Please.
or else their right to file the objection shall be forfeited.
Please.
In the
67.
meanwhile, records may be called.
Huh?
Records may be,
And the records from the medical counsel
medical council, since they have
the-
conducted inquiry.
all the records shall be placed before the court. There's this matter on 16th of June.
Lord, me-
Yes,
Cell number
Interim order.
67.
interim order already
Please.
granted is extended.
Murli
67,
BS. 67 Murli BS.
For
Lord,
the
appearing for the
petition.
respondent bank, I'd filed my objections and served soft copy, my lord, hard copy, I'll serve it on
Lord,
them.
soft copy of the objections, my lord, alone is sent to me. None of the
Serve the hard
documents, my lord,
copy
are
now,
served.
my lord. Maybe taken up.
Documents, my lord, are not served on me.
No, we've served, I'll serve it, my lord. I'll serve it. It may be taken up tomorrow.
when do you want? Is there any interim order?
No interim order, my lord. This is all I'm requesting, my lord, is to refund my money, my lord. I'm an auction purchaser. I purchased the property in
I'll serve
2018.
it, my lord. I'll serve during the course of the day. We filed it. Yes.
Tomorrow, or you want after vacation?
Not tomorrow, my lord.
Tomorrow.
Great.
Yes.
For dismissal matter, cell number 68. 68 Raju CN.
Take that. You have a copy of it, Mr.
Please, my lord, they served just now, my lord.
Since 4 months time, my lord, to pay the amount.
He says due amount of rupees 47 lakhs,
No, my lord, that amount is very, my lord. 48 lakh plus unapplied interest as on today,
48 lakhs.
plus unapplied interest. There are some interest component also, some other charges also there. It is, my lord, they're indicating in respect of section 17, which I, section 14, which I filed in
What
the.
is here? No, Mr. Counsel, I'll take it up in the afternoon, get instructions from him, and that
Instead of
amount.
instead of that, I mean, my lord, I'll not, whatever bank outstanding, they'll,
That you change and take his signature.
my lord, I have one more submission, my lord. Instead of 4 months, in fact, bank given sufficient time. It may make it 2 or 3 months, my lord.
We'll see. Only as far as this amount is concerned, instead of mentioning the amount, whatever is the outstanding amount due to the bank, that you please make corrections and take his signature. And ask him to be present in the afternoon. Yes.
Cell number 69.
Respondent bank.
Then Ryan.
In this matter, I'm the petition. The lordship kindly pass out 30 lakhs DD is ready.
Huh?
30 lakhs DD is ready. Remaining 9,70,000 within 2 days we'll make it.
It's not
2
acceptable.
days only.
He's an auction purchaser. He's seeking installment to pay the balance of sale consideration. A substitution.
Okay, I said, whatever is the amount is ready today, I'm going to pass orders.
Please.
Or else I'll dismiss it. Pass over. If you come with the deal for the entire amount, we'll consider, or else I'll not take part payment. First of all, you're not entitled for any relief from this court. Pass over. Yes, next, orders.
Pass over. List number 2. For orders matter, sale number 1.
What about this?
List number 2, sale number 1.
Readings are completed, my lord. Objections are filed. Petition itself is not maintainable, my lord. Kindly
No
see my statement.
representation. This is matter after vacation.
Sale
Yes,
number
next
2.
two.
Sale number 2.
What about this?
Settlement. B report is filed, my lord. On 19/10/2023.
The writ petition is filed seeking the following prayer.
Prayer is at page 24, my lord.
Seeking the following prayer. Then there is no, when the matter came up on the last occasion, there was no representation. On behalf of the petition, the matter is directly listed today on the caption dismissal. Today also, there is no representation. Then counsel, then at HCDP, appearing for the respondent submits that when the petitioner has given a complaint they have conducted the inquiry and a B report is filed
On 19/10/2023, my lord.
on 19/10/2023. It is submitted that in the light of the same, they cannot grant any protection to the petitioner and the petitioner's remedy is before the civil court. A petitioner before remedy is elsewhere. Next, considering having heard the learned CGP, there is a material on record. The relief that is sought is seeking police protection to the petitioner against the local residents. In that regard, the police have already conducted investigation and they filed a B report and the petition is not entitled for any relief from this court. Accordingly, the petition is dismissed. Next.
In this matter, my lord, there is a
Petitioner in this case, my lordship. There is no complaint at all. Without the complaint, enter the premises of petitioner, my lordship.
Come to the prayer. What is the prayer you are seeking?
Consider the representation, my lordship.
What is the representation?
And
Directing
26,
the respondents to consider the representation dated 11/8/2022. What are your instructions?
My instructions are, my lord, there is a dispute between the husband and wife, my lord. Both are appeared before the IO, my lord, and they have given statement, my lord. They will clear their dispute before the appropriate forum, my lord. Recording the statement, my lord,
Yes.
it is closed, my lord.
no, my lordship. Kindly see. Without complaint, enter the premises of the petitioner, my lordship.
That is not part of this writ petition.
Petitioner detained for whole day, my lordship, without
For
complaint.
that, you have to file another writ petition and seek the relief that is independent. What you have asked here is to consider your representation. What is the representation?
Representation, my lord. Initiate action against the police officer, my lordship.
That is alternative remedy. sir.
RTA
That is the remedy available, my lord, 20D.
20?
D of Karnataka Police Act, my lord.
Actually, madam, they have to comply this honorable court direction 7/11/2022, my lordship.
Where is that?
22. Kindly see the order.
7/11?
2022. Learned AG is directed 7/11/2022, my lord.
The AG director accepts
Directed to
notice.
secure the instruction as how the police enter the property of petitioner without
Based
any
on the
rhyme and
complaint
reason.
of the wife, my lord,
Oh, you have to file objections.
I will file, my lord.
And thereafter also repeated on
I think this is high time, this is
3/3/2022.
high time that this
Till today,
practice
they
of,
have this
please
honorable
wait.
direction.
This is high time that, you should stop this practice of just watching the proceedings.
No, my lord.
When the state is a party, allegations are against you, you're supposed to file your objections. Nobody has to tell you.
Kindly see the ink page number 20, my lord.
An order was passed on 7/11/2022, directing the AG to secure the instructions as how the policeman entered the property of the petitioner without any rhyme or reason. This order is passed on 7/11/2022. Unfortunately, till today, the respondents have not filed their objections. Objections shall be placed on record by 3rd of June, or else the second respondent shall be present before the court.
Much obliged.
Delete from the caption for dismissal.
Number 4,
It's for the petition.
Ahmad.
My lords, this petition is filed for direction for reinvestigation, my lords. Here, my lords, the UDR was registered, my lords. But according to the medical report, my lord, at page number 29,
The prayer. Let's see that.
prayer is direct the respondent number the CADR respondent number 4.
Direct the respondent number 3 for reinvestigation, de novo investigation by fresh team of investigations to be headed by senior officer of the state, consisting of efficient personnel, well conversant with the use of modern investigation technology. Yes.
My
What
lord,
happened to this?
Objections are filed, my lord.
Let's see.
Yes, my lord.
Have you received the objections?
Yes, my lord. Received the
Have you
objections. my lord.
filed, is there anything to reply to that?
Yes, my lord. In
To
in
file-
there. My lord.
Did you file your reply to that?
No, my lords.
Then file it. If you have any objection on that.
No, my lords. In their objection also, they have said that there are 14 external injuries. On that, I am relying, my lord. That's all, my lord.
Let's read your objections, Ms. GP.
Annexure R7 onwards, my lord, is relevant. Paragraph 5 onwards, my lord. May I read, my lord?
I'm reading from paragraph 3.
Please.
ಇಲ್ಲ ಇದೆ ನೋಡಿ. ಎತ್ಕೊಂಡ್ಬಿಡ್ತೀನಿ. ಫಾಸ್ಟ್ ಆಗಿಲ್ಲ. ನೋಡಿ, ಇನ್ನೊಂದು ಅದಕ್ಕೆ ನೋಡಿ. ಅಷ್ಟೇ.
Where is that postmortem report?
Lord, that page, my lord. Forty-six onwards, my lord, there was an increase. Confidential report is also obtained, my lord.
46.
46 onwards, my lord.
What is number 2? Multiple contusions of so and so is present over the center of lower lip. What is that? Can you see?
Because she fall on the hard surface area, my lord, that
That's
was
what
also
I'm
stated.
trying to
Please, my lord.
understand. One is on the forehead, above the middle of the
Yes,
eyebrow.
ma'am, above the middle of
Then
eyebrow.
multiple
Confusions of size 1 into so and so present over center of lower limb. Confusion of so and so so and so. These injuries are caused due to the fallen of the deceased in hard surface area, my lord. Measure was done. That is stated in paragraph 12, my lord. How it was that injury is caused.
No, if she has sustained injury
Because
in this manner.
At that
She has
time, my
fallen
lord, she
on
was
a-
affected with COVID positive, my lord. She was-
No, how will the ear
That
will
is
get
also-
affected?
She fallen into hard surface area, my lord, in the bus stand.
Correct.
Yes, ma'am.
Either she has to fall like this
Yes,
or
ma'am.
on the head.
Yes, ma'am.
And how will the earlobe, there will be an injury if she falls down like this?
Over the head, the chin, cheek, left mid-arm, left elbow, knee.
There are 14 external
She
injuries.
friends.
So what did you do? You said it is, you have
C
filed a
report is
report.
filed, my lord.
Hmm.
Till today, my lord, that C report
Why
is
you have
not
not
challenged,
questioned
my
that
lord.
C report?
My lord,
Why you have not
And
questioned
nor in
that
this petition, my lord.
C report?
my lords, it is not available for us. My lords, only the UDR
the
was
objections-
registered. I filed multiple
How
complaints.
can
The
you
year
file a
20
C report without a copy to them?
My lord, copy is issued, my lord. They
No.
have a knowledge,
You
my lord.
have the signature on the copy?
I will get that. You have signature, my lord. That is mandatory, my lord. Before filing C report,
That
my
is
lord.
not,
Yes,
there
my
are
lord.
so
It is
many
similar
things
matter. Yes, my lord.
mandatory,
Yes, my lord.
which you people don't do.
Yes, my lord.
By the next date of hearing, then SCGP shall place before the court. the C report and that is filed and the endorsement on that to show that the same is served on the petitioner. If the same is, furnished to the petitioner, petitioner's remedy is to question the same. This is matter on 11th of June.
Please.
Yes.
Let's
Any
in,
passwords?
let's in the July, my lords. I'll not be here. I'm going to
Yes, July,
apply.
on 1st of July. Yes.
Passover matters. List number 1, serial number 7. Passover matters, serial number 7.
Sorry to interrupt, my lords. On 5th or 6th, my lords. I'll be coming on 1st of July, my lords.
6th of July. Yes.
Serial number 7, list number 1, Passover.
Section 14 order assailed. This
Can you-
intent-
If both of you are there, I'll take up. Is not there, I'll take up after lunch.
Serial number 8.
Pastor,
This also,
Serial number 8 also.
same advocate.
Serial number 9, the 11. Serial number 11.
Made please.
Yes.
When is
I'm
the,
told they're proceeding with the suit. They're proceeding with the suit.
Yes.
Why should this application be not considered? This order 7 rule 11 with regard to the deficit.
I'm in a piquant situation, my lord. I have challenged the validity of 5.2 because that's the specific, my lord,
Entire
constitutional.
suit proceeding should have been stayed. No, why should, what is the benefit you're getting by only staying that application, that IA?
Lord, the
No,
outcome of the writ petition.
No, pending this writ petition. Now the suit is proceeding. If the suit is decided,
Lord,
your writ petition,
may I, Lord, suggest this? There are two applications that they have filed. It seems they made a submission in the morning. That one is, my lord, with regard to court fee under 11D.
yes,
One is under D. They are separate applications.
Yes.
However, my lord, both are stayed in the present proceedings. Therefore, my lord, the interim order is of 2015. They filed an application now for vacating the order. Lord, so far as the
he
interim
is
order,
concerned. Order 7 rule B is concerned with.
B, my lord, the trial court can proceed.
Yes. Please give the order sheet.
At the same time, my lord, may I just add something, my lord? This writ petition is of the year 2015. We had moved the application for vacating it or modification of the same in the year 2021. No objection is filed by them till date. Over and above, the central government had supposed to file their objection.
We're not going to that. If you want it, I'll legend the entire.
Yes, my lord.
We'll hear it.
As
Or else I'll only clarify
tomorrow,
that.
the matter is for listed for the purpose of recording of evidence. On the
My evidence,
5.2
I'm
also,
supposed.
on 5.2 also, they'll have to lead evidence. Otherwise, then I'll be losing my right if this is stayed here.
You asked, he's agreeing as far as your application is concerned.
There are two applications. One anyhow that is not concerned with respect to this particular petition, my lord.
I think that is what is the submission made by you in the morning.
Yes.
That is what I'm going to pass orders and what other submissions that the court should hear.
The second one is, my lord.
That I have to hear it after hearing the entire, disposing of the entire petition.
Very well, my lord. At least a date may be fixed for that particular. Because this 2015 matter.
Order was passed by coordinate bench of this court on 2/12/2025, where the application filed under Order 7, Rule 11B and 11D of the Code of Civil Procedure was, the stay was granted in regard to those proceedings before the trial court. Then counsel appearing for the respondent defendant submits that the issue is with regard to the order impugned is concerning the Order 7, Rule 11D, but that Order 7, Rule 11B is concerned. The stay is granted by the court, by this court, and the trial court is proceeding with the matter. However, this application is not heard in view of the stay, considering the fact that the petitioner is concerned with the order that is filed, that is passed under Order 7 Rule 11D. This court deems it appropriate to modify the order dated 2/11/2015, confining the stay to the application filed under Order 7 Rule 11D, and the parties can proceed. The court shall proceed further as far as considering the application that's filed under Order 7 Rule 11B. This is matter after vacation on.
Can it be on, Manoj, may I request for 4th of June, my lords, because I have to come
This is
from
matter
Chennai.
on 4th of June.
Grateful to you.
Number 19. Serial number 19.
Appear for the petitioner's counsel, my lord. This is that
Yes,
one.
Mr. Mutana.
An application has been filed to amend the writ petition, my lord.
Huh?
Application has
On
been filed to amend the writ petition.
On the last occasion, your lordship directed orally to the opposite side to file an affidavit. So
affidavit
as to
no.
how many people they have
Lordship
given
has
the
directed me to find
one-time
out
settlement.
whether that he has submitted any application for it.
When counsel for the petition submits that the OTS scheme is in force.
Yes.
Then counsel for the respondent bank shall get specific instructions.
Yes, ma'am.
Yes.
I got the instruction and today they called him for that OTS. And it seems the party told that today the case is there, he will not come. Then I told him if he has not come, tomorrow or day after one of the date we fix and take his OTS and
This is
decide.
matter after vacation.
And my lord, this
The,
application.
Interim order.
Submitted with the land council appearing for the respondent bank that for the one-time settle to discuss a one-time settlement offer, they have called the petitioner.
Interim order may be extended.
The interim order earlier granted is extended till then. Yes, next.
35.
All after vacation.
After vacation is the matter on 9th of June.
Grateful.
35.
35.
35 objections are ready, we'll file it.
Huh?
Objections are ready, I'll file it by 2:30, 3 o'clock, I'll file it.
When do you want?
Wednesday, we can dispose
Wednesday,
it.
this is difficult. What is our morning? The petition was there.
Is there?
So then let's see when in his presence we'll pass an order. Pass over again.
Yes, my lord.
Yes, next.
44.
44, my lord, kindly see the order, whether the subsequent, whether the notification question is
No,
withdrawn or not.
They were there.
They were there. And my instruction that notification is withdrawn.
We'll pass orders in.
Yes, ma'am, please.
Pass over. Next.
Serial number 51.
Even I'll file my formal objection because they said that there is an admitted amount. And I have instructions that, no, it's not admitted.
I will post this matter on the reopening day.
Yes.
By that time, if they don't file the objections, I'll say the petition stands alone.
Not reopening, madam. 5th or something like that.
The Leonard AGH seeks time for filing objections. Lists this matter on 4th of June. This writ petition is of the year
2023, madam.
2023. If the objections are not filed by that day, the right to file the objection shall be forfeited, and basing on the amendments and the case of the petitioner, the orders will be passed in the writ petition.
10th, my lord, instead of 4th, 10th.
10th.
Reopen.
Yes. Next.
Serial number 68.
Huh? Is corrected?
69.
Maybe after we'll take it up at 2:30. Yes.
69. Surendra N.
69.
9.
Yes, this also password. Ring the bell, he has to come. I'll do it.
My lords, I would like to make a mention.
No mentions now.
Memo for being spoken to, my lords.
Why you have to move it now? You should have moved it in
Apologies,
the
my
morning.
lords.
No mentionings now.
Apologies, my lords.
No apology. It will be only in the morning.
Please, my lords. The orders were,
No, nothing. I'll not hear anything.
Apologies, my lord.
Sir, 57 ಏನಾಯ್ತು ಸರ್?
What officer? What officer? What officer?
ಹೇಳಿ ಸರ್. ಹಲೋ.
Fast list one, no? Srikanth. Hello?
ಹೇಳಿ
Hello?
ಸರ್.
ಅದೇನ
ಹೇಳಿ
61 61ನೇ ಮ್ಯಾಟ್ರ್ ಏನಾಯ್ತಮ್ಮ? 61ನೇ ಮ್ಯಾಟ್ರ್ ಶ್ರೀಕಾಂತ್.
ಏನ್
ಫಾಸ್ಟ್ ಲಿಸ್ಟ್ ನಂಬರ್ 1. ಸೀನಿಯರ್ ಕಾನ್ಸ್ ಎಂಗೇಜ್ ಮಾಡಿದ್ದಾರೆ ರವಿಶಂಕರ್ ಅವರು. ನಾನು ನಮ್ಮ ಮಿಸಸ್ ಹುಷಾರಲ್ಲೇ ಚೆನ್ನೈಗೆ ಬಂದಿದ್ದೀನಿ.
ಸರ್ ನಾಳೆಗಿದೆ ಅದು ಮ್ಯಾಟರ್.
ನಾಳೆಗೆ ಹಾಕೊಂಡಿದ್ದಾರಾ? ನಾಳೆಗೆ ಹಾಕೊಂಡಿದ್ದಾರಾ?
ಹೌದು ಸರ್.
61 ಶ್ರೀಕಾಂತ್.
ಸರ್ ಹೌದು ನಾಳೆಗೆ.
ಆಯ್ತು ಆಯ್ತು ಆಯ್ತು.
Kindly leave, my lords. Serial number 35, passed over matter, my lord. State just now served a statement of objection. I will go through the statement, my lord. I will make my submission. Kindly have it tomorrow, my lords.
Pass,
What is that?
pass over matter serial number 7. Which serial, sir?
What is the 35?
No, no,
35.
today,
These are the
today,
passed over.
I was directed to file objections that I have served it and I am filing.
Tomorrow?
Not tomorrow,
35.
Well, Thursday, there is.
Last working day, it's not possible. Or
Wednesday,
Wednesday.
Wednesday.
So matter on Wednesday.
Please.
Yes.
I am permitted to file in the, if I file it in the registry, it will take time to come in. That's
If the learned AG has filed his objection, the same is served on the constable
Yes, madam.
petitioner. Petitioner seeks time, list day after tomorrow.
Please, ma'am.
Please.
Yes.
Sir, serial number 7, pass over matters, list 1, serial number 7.
Yes.
That's I'm for the petitioner in this case, my lords.
With the motion,
In this case, my lords, section 14 order was challenged before this honorable court. Page number 25, my lords. Annexure A. my
On what ground?
Page number,
What ground?
my lords, the only ground which I had pleaded before this honorable court is, my lords, on 29/3/2026, my lords. 29/3/2025, page number 70 of my writ petition. I have filed detailed objections why the section 14 order should not be allowed in favor of the bank, that is the petitioner before the honorable magistrate.
Oh, at that
And my lords,
stage,
that is taken on record
you're a
in
borrower.
criminal miscellaneous.
You're a borrower.
Yes, yes.
Then what is the borrower's role before the court?
My lords, I have filed my objections, but my lords, the objections has not at all been considered by,
I'm saying, you require no audience before the
yes, my lords.
magistrate.
That-
And that kind of an order can't even be assailed, even if he gives you an audience. And if your contention is that nothing is not necessary to record, isn't it?
Yes, my
Is it
lords,
not the
but that
second
is
law?
why, my lords, that is why in the morning session, my colleague had filed a memo, my lords.
Court, you come to the court, taken an interim order, don't comply with the interim
My lords,
order, enjoy the
that,
stay.
my lords, that was a conditional interim order, my lords.
No, it is not, it doesn't look like so. Then look at it further. If it stops there, it's fine. What it says,
My lords, I'll leave it to this court, my lords. I filed a memo
oh, it
seeking for
says-
withdrawal.
That's what I say. I'll give it, but I'll not say that you have the benefit of section 14.
Yes, yes.
The writ petition is, the memo is filed seeking to dispose of the writ petition. Accordingly, the memo is taken on record and the writ petition is disposed of, giving liberty to the petitioner to avail the appropriate in accordance with law.
serial number 8, same.
48.
My lords, in this case, in the last date of hearing, this honorable court has heard everything at length, my lords. This honorable court directed me and the bank to file the written arguments. We have already filed, my lords. It may be reserved for orders is my humble submission. That's my written arguments may be taken on record.
Where are your, both the counsel for the petitioner as well as the respondent have filed the return. I can find the return, where are your written?
I filed, my lord. I filed before the registry.
Both the
think it is
counsels to file the written submissions, heard reserved.
Grateful.
Serial number 44. Serial number 44.
Lords appearing for the petitions. We were to seek instructions whether the notification has been.
No, he says it is withdrawn.
Notification is withdrawn, my lord.
Very well.
Then it became infructuous.
Huh?
This petition
Be the
became infructuous, my lord, because the separate notification under the KPID Act is already issued.
The writ petition is filed, seeking the following prayer. The learned, on the last occasion, when this matter came up, the learned counsel for the learned AG has submitted that the notification that is impugned in this writ petition is submits that the subsequent notification is issued. Then this court has directed the learned AG to get specific instructions whether this notification is withdrawn or not. Today on instructions, learned AG submits that the notification is with the notification impugned is withdrawn. In that view of the matter, nothing survives a consultation in this writ petition. accordingly dismissed as infructuous, leaving open to the petitioner to avail the remedies to question the subsequent notification in accordance with law. Yes.
Cell number 68. 68.
Take that memo from. Yes. Your submission is 2 months. The writ petition is filed, seeking the following prayer. When the matter came up for hearing, then counsel appearing for the petitioner on, not on, give the date, on 8/4/2026, then counsel for the petitioner submitted that they are ready to clear the entire outstanding amount. Hence, the matter is adjourned on 2-3 occasions for filing the undertaking affidavit. Today, the undertaking affidavit is filed before the court. Party is also present. And the party is also present before the court. The affidavit is filed stating that they are ready to pay, they undertake to pay the outstanding amount to the bank without fail within 4 months from today, and requested the court to grant 4 months time to pay the loan amount. Land counsel appearing to the respondent bank submits that the proceedings are initiated when.
My lord, the order as filed before this honorable court.
Loan itself is sanctioned on 2024.
My lord, quick mortality, please.
Criminal miscellaneous 25. That the proceedings, it is submitted that
From 2024.
there may be a direction to the respondents to pay the amounts within 2 months. Expert, having heard the counsels on
One, my lord, my objection one may be recorded somewhere, my lord, one, some objections in respect of maintenance of the writ petition.
It is submitted that petitioner ought to have, but petitioner has to appear before, has to avail the remedy before the DRT, but he cannot come before the court. Further, the 4 months time cannot be granted to the petitioner. He is not entitled for 4 months time. Next part. Having heard the counsels on this side, there is a material on record. Considering the undertaking affidavit that is filed before the court. This court deems it appropriate to dispose of the writ petition in the following manner. 1. The writ petition, as per the undertaking affidavit filed by the petitioner, he shall pay the entire amount by 4 months means today is 27. May, June, July, August. By August.
I think July, my lord, for me 2 months, for him 4 months. At least 3 months is, I think, my lord.
By August 27, he shall pay the.
That is the case, my lord. In meantime, otherwise, my lord, he will already be given time. Another 4 months he will enjoy. He will not pay anything. At least in the interim, some amount in the month of.
The entire amount by 27th of August. If the petitioner fails to honor the affidavit that is filed before the court, he shall pay cost of ₹1 lakh to the respondent bank. The respondent bank, if the petitioner fails to pay the amount by 27th of August, the respondent bank is at liberty to take further steps in accordance with law.
Cell number 69, Surendra N. is post. Sir, start with paying.
This matter I am the
Cell
petitioner,
number 69.
Your Honor, for a moment, Your Honor. Rule 9(4) is clearly states this, Your Honor.
You please don't go to the rules.
No,
You're ready with the money. I'll hear. Otherwise, I'll not hear.
By tomorrow itself, I have it, Your Honor. I will furnish the deeds.
Tomorrow, no further. Tomorrow, this is matter tomorrow. No further adjournments. Tomorrow, if the petitioner is ready with the entire amount, as per the outstanding, as per the OTS, and
It's not what is
auction purchase.
Auction purchase.
as per the auction, if he is ready with, with the entire amount, with the DD for the entire amount, the case will be considered or else the same will be dismissed, no further time will be granted.
Great. Second March, you had enough time.
Huh?
From second March.
Tomorrow I'm dismissing it. Yes, done.
ಇದೊಂದು ತಗೊಂಡು ಹೋಗ್ತೀರಾ? To take this one file, okay? To get it signed and the other file I will send after. ಅವ್ರು photo ಬಿಟ್ಟಿದ್ದ ಅದೊಂದು ಬರೀ order ಜಾಸ್ತಿ ಅದು